Good morning, everyone. This is the Lincoln Heights Parliamentary Virtual Retreat. Today's date, Saturday, March the 6th, and we're going to start with the introduction of council. We have this morning, we have Vice Mayor Jeannie Stinson, Councilwoman Linda Childs Jeter, Councilwoman Laverne Mitchell, Councilman Durance Daniels, Councilwoman Tanya Key, and then I'm sure that we'll be having Councilwoman Phyllis Baber. Is there anyone that I did not introduce before I continue? And me, Mayor Ruby Kinsey Mumphrey, along with our distinguished guest. We're going to go ahead and proceed. I want to welcome Mr. Michael Hennenkamp from Ohio Plan.
Thank you, Mayor. Welcome, everybody, or good morning, everyone. I think you can.
Good morning.
Can everybody see my screen?
Yes, sir.
Yes.
Some head nods, so it sounds like we're good. Well, I appreciate the opportunity to be with you. I just give you a brief introduction of who I am and what the Ohio Plan is. As Mayor mentioned, my name is Mike Hennenkamp, and I'm the Executive Director of the Ohio Plan. I have been involved with the Ohio Plan for about 25 years now, and about 22 of those years were as a board member, and then over the last 3 years, I have been appointed as the Executive Director. So overall, I've got experience, about 33 years of local government experience. Most recently was a township administrator in Springfield Township, just kind of just your neighbor, a little bit to your, I guess your west and maybe a little bit to your south. I also served some time as the assistant administrator in Westchester Township and also planner in Green Township. I am getting a lot of feedback, so if it's possible, if we could make sure that everybody is muted. I'm hearing my voice back as I talk, and that's not a good thing. It's bad enough to hear it once, right? And I got to hear it. I got to hear an echo. So I think that solved it. So whatever we did, and then certainly if you have a question, then unmute. But at this point, so what is the Ohio Plan? The Ohio Plan has been around for about 32 years. And we are a risk management pool. So we provide property and casualty insurance exclusively to local governments. So the only thing we represent is local governments. We are member driven, and so we are actually owned by our members. And we represent cities, villages, townships, special districts of all different types. And then in addition, when you're a member of the Ohio Plan, your entity also automatically becomes a member of a companion entity that we have that's called Ohio Plan Management Resources. And so it's actually through that organization that we're able to provide the training today. So Lincoln Heights, certainly not a member, but we do have a relationship with the Center for Local Government that allows members who are involved with the CLG to take advantage of some of the offerings and some of the services that we provide through the Ohio Plan Management Resources. So certainly if there's ever interest by the village to get a quote and would like to become a member of Ohio Plan, Mayor or somebody from your staff, love to talk to you about that. I'm not sure who you are, who your property and casualty insurance is with, but we do offer a lot of resources to our members that I think could be quite helpful. Again, just quickly with what we do, our goal is to help public entities excel. And we do that in a wide variety of ways, but we also want to keep you safe and unexpected from adverse situations. And those are things that obviously can happen. That's why you have insurance, not only for property related issues, but also for liability and protecting the entity. And certainly what we're going to talk about today deals with a lot of the liability aspects that that a village or a city or any public entity could face if you don't, take the proper steps and have the proper protocols. So prepare, partner, protect. That's kind of our tagline. Those are the things we do. And again, that's who we are, what we do. And if there's ever interest in the village learning more about the Ohio Plan and how we can help, certainly interested in talking to you. But that's enough about who we are. Now we'll get to sort of the focus of today's, at least my portion of today's session. And that is to discuss the obligations to ensure open and ethical conduct in government. This is a difficult topic, or a series of topics, because it's certainly not exciting stuff. In fact, if you had to come up with 3 or 4 topics that might be the toughest three or four things to talk about, this would certainly qualify as being pretty boring and pretty dry stuff. But despite the fact that it's not real exciting stuff, it is very, very critical. And certainly we've had, unfortunately, plenty of examples recently in the news, not just across the country, but certainly here locally, of how public entities, public officials have gotten themselves in a whole bunch of trouble for the fact that they have not complied with Ohio law regarding open government or Ohio ethics law. And we'll touch on those a little bit as we go through. As I discussed with Mayor Mumphrey, we're going to take a really high level approach today. These are a lot of these topics. You could spend a day just on any one of them if you really wanted to do a deep dive. That's not our purpose today. As elected officials, you're often not going to be dealing to the level of complexity in the day-to-day and having to make all of the specific decisions, but you do want to have a pretty good idea of the general principles that apply in these areas, and certainly some key areas in which your individual conduct you could become a problem if you're not aware of what the law is, and if you do some things that even you may not even have nefarious purposes for why you're doing them, but you can get yourself in trouble if regarding open meetings and records and things of that nature. So that's where we're going to go. We'll start really with the 3 statutory provisions in Ohio law that are in place to guarantee open government. And the first one we're going to talk about, and we'll talk pretty briefly about this one because this gets very, very complex. We want to just kind of hit some highlights, and that's the Ohio Records Retention Act. It is Ohio Revised Code 149.351. And before I go any further, I just want to mention, and I think I mentioned this to Mayor in one of our phone conversations. On some of the slides, I'm going to have a lot of words on them. Typically, that's not what you would do in a PowerPoint presentation. And the reason I do that, or the reason we do this with the Ohio Plan, is that I'm going to send you this presentation. So if you're furiously trying to take notes and things of that nature, don't worry, you're going to get this actual PowerPoint. I will send it to Mayor, and then she can distribute it accordingly. So I like to put a lot of these things on the words or a lot on the slides, because it's that way it serves as a nice referral for you. If you want to look something up, you can go back and it'll have a lot of these case sites and so forth. The other qualifier I need to mention is, and I should have done this in the beginning, is obviously I am not an attorney. I've got about 33 years in local government experience, so I've dealt with this on a sort of a very practical standpoint and have been involved with this. But this particular presentation was put together by our general counsel, Laura Abrams, who I've worked with for pretty close to about 25 years. And so while I'm not presenting this as an attorney, this is a presentation that was prepared by our general counsel. So again, the first one, the Ohio Records Retention Act. The second statutory provision we're going to talk about is the Ohio Public Records Act. And then the third is the Ohio Public Open Meetings Act. And we'll get a little bit more into the latter two than the first one, but we'll dive in. So really what each of these acts in what they require, the Records Act is that records, that you have an obligation in the village of Lincoln Heights to maintain your records. And there's a certain time period that records must be maintained. A good deal of those, you don't have much discretion. The law will tell you how long you must keep a certain record for. And then there are other areas and other record types where you have great discretion, but you have to identify that and we'll talk briefly about how that is done in your retention schedule, in which you spell out how long you're going to keep certain records. The Ohio Public Records Act is pretty straightforward, and that is an act that allows the public to view your records and have access to those records, and that you have to provide those records in a timely manner. And then the third, the Ohio Public Meetings Act, is that your meetings and everything that you do must be done in the public, so that the public can attend your meetings. There's obviously some exceptions to that, and we'll talk about what those are. But generally, those are the three areas that Ohio law has in place, the three statutes that guarantee that government is open. So let's start with the first. And again, as I mentioned, we're not going to spend a whole lot of time on this one because this can get really, really complicated and you can really get bogged down in the weeds on this. So we're going to hit sort of the highlights. But what this act, there's really three things that this act does. The first is to establish that all records are the property of the public office concerned. So in this particular case, everything that is in your village building or any record that's documenting the activities of the village is owned by the village of Lincoln Heights. The second primary purpose of this statute is to prohibit the removal, destruction, the mutilation, the transfer, the damage, or the disposal of those records, except under those very, very specific provisions that the law provides for, and then also very specifically towards the records retention schedule that you have adopted in your jurisdiction. So if Lincoln Heights does not have a records retention schedule and never has, or you've never heard of this, this would be an area that you want to immediately address. As I said, it can be fairly complicated, but once you get the gist of it and you have the schedule, it provides for a much more orderly understanding of how your records are kept, what you can and can't do with them. And then the third piece, obviously, is the requirement that the delivery of the records by outgoing officials and employees to the successors, so that as administrations change, as new elected officials come on board, these records are there, and that you have an archive and you have a sound foundation for the activities of the village in your case. This just gives you kind of a rough idea of what a typical, maybe one page of a records retention schedule would look like. It doesn't have to be exactly like this, but this gives you a pretty good idea of, you're identifying on the far left under item number 1, the schedule number, you're identifying the record. You're giving it some type of name so that you can easily file it, classify it. That's pretty discretionary. The second type describes what that record is. And this is important because as you look in the Ohio Records Retention Act, it will identify what records and where you have great discretion, and then what records that you must follow a very strict procedure for. Some of them you have to retain a paper copy forever. An example of a record that you have great discretion is emails. most people might not think, and certainly in the last 25 years, we have a lot of records that are now, most people don't think about them because they're electronic records. They may never have been printed, they're just electronic records. But those emails, if they're documenting something to do with the activity of the village, are actually a public record. Now, you could destroy those emails in certain situations on a daily basis. If that's what your record retention schedule says, you can delete them immediately. But you're not able to do that, and you have to keep that email forever if you have no record retention schedule or your record retention schedule doesn't address it. So again, just a quick idea and just a quick sample of what a record retention schedule might look like. And as you can see, there's records that are permanent. How it's going to be maintained is on paper, and you're keeping those annual records and annual reports forever because that's what you've identified. Where you have other types of records where you can destroy immediately, whether that's paper or electronic. As I mentioned, the key here really is that the record retention schedule is everything. Once you have crafted a records retention schedule, then you work very hard to comply with it. And assuming you do that, it's a pretty simple process. But if you don't have a record retention schedule, you can see the downside of that. Is that essentially that means without it, you're keeping every record that you have and every document that you have in the village forever. So very, very important. That's an almost impossible thing to do. So very, very important to get the record retention schedule adopted and maintain compliance. With all of these statutes, the three major statutes that we're going to talk about this morning, there's penalties involved. And these penalties, if you follow the news and you think, well, this will never happen to us, well, maybe you may get lucky, but you might not be so lucky. And in cases where somebody has filed suit because they're saying that they believe you've destroyed the record or you haven't maintained the record as required, the fees and the penalties can be pretty substantial, as you can see on that slide. So that's all we're going to cover with the record retention schedule. Again, if it's not something that the village is intimately familiar with, again, you can go to, there's plenty of seminars. I think the state auditor, some state offices probably offer this on a fairly regular basis. And if it's an area that you think you're have deficiencies in, certainly get some training or get some assistance, and definitely want to move forward to get your record retention policy set. Second item that we're going to talk about, or statute we're going to talk about, is the Ohio Public Records Act. And so the Ohio Public Records Act really requires the public entity to do a number of things. And the first is that you provide the prompt inspection of public records to the public. So certainly any of your residents or anybody from the public. So, it's not just somebody that's a resident in the village of Lincoln Heights who has the authority and has the ability to review your records. It could be me. I could walk in on any business day and say, I'd like to see your minutes of a council meeting, or I'd like to see your budget. These are all things that anybody from the public, the newspaper, the media, it really isn't endless. There's pretty much anybody that's entitled has the ability to view those records. And also I could request copies of whatever records that you have. Again, the act talks about reasonable time, depending on the very, very specific request that I'm making. If it's something that's pretty easy for you to provide, the council minute meetings would be one of the easiest things. You should have those readily available, and a copy that I should be able to pretty much walk in and walk out that same day with. But if I'm asking for a very, I want records that are going to be very voluminous, that are going to have to be sorted, so forth, and processed, a reasonable period of time can sort of be negotiated. The statute's not necessarily very clear on what that is. But if somebody feels that, I've waited a month for this and now I'm going to file an injunction, a court might feel a month is far too long, or even 3 days is too long, depending upon what that specific request is. So what is a public record? And there is, again, we're touching really just on the surface of a lot of these areas. The public record, those three categories, is something that's held by the public office. So it doesn't mean that it physically has to be in that office necessarily, but it is something held as a document that is owned by the village. It's stored on a variety of different ways. It could be a fixed medium such as paper, but it's also could be electronically stored. It can be on film of some type. It's created, received, and sent under the jurisdiction of that public office is the second. And the third one is really the most important one to remember, is that in order for it to be a public record, it has to be a document that it has to be something that documents the function of your organization. Whether it's a decision, whether it's a policy, whether it's procedure, operations, activities of the office, something that is actually village business related. And an example of that would be, let's just say, one of the council members or one of your staff members sends an email to his wife or to their husband or to a family member. And it's completely personal. Now they've used the village email to do it, but it might even, let's say it's even racy. There's a sexy message, or there's something very, very personal between these, husband and wife, or boyfriend, girlfriend, or some family member. And word gets out that this person has used the village email for this, and somebody in the media or some opponent wants to get a copy of that email. That is not a public record, because that document, again, assuming that there's nothing in there that's documenting or discussing village business, despite the fact that it was done on village, property, despite the fact that it might actually rest in the email server of the village, it's actually not a public document, because it's not documenting anything or any activity or function of the village. There may be other problems with the fact that depending on your policy and whether a staff person or council member can use village email for that purpose, that's a whole different issue. But as far as we're talking about with public records, not an issue from that standpoint. And that is a big misnomer, I think, a lot of times. Now, having said that, I certainly wouldn't encourage you to do that. I certainly wouldn't encourage you to use village property in that fashion and try to really limit personal things, because it can always be this gray issue where, maybe 80% of that email was in fact personal, but there was 20% or something mentioned business, and which then in fact makes it a public record. So you want to be careful with it. The best, certainly the best practice is to avoid it completely, but remember that is one of the central criteria for it being a public record, is that it actually documents something that the village or the public entity is doing. There are certain records that are exempt from disclosure. So assuming somebody were to request these particular things, there are certain medical records relating to a patient's medical condition or an employee's medical condition that are generated. Those can be made exempt. If you're involved in litigation, certain trial preparation materials specifically compiled in reasonable anticipation of offense of that litigation can be exempt, at least for a portion of the time or while that litigation is pending. And then peace officers, firefighters, I'll have some greater exemptions to their personal information than many of the other staff members. And this is really a result of something that took place at 9/11. After 9/11, there was a strong push to have greater exemptions for police officer and firefighter records. This can include their personal address, social security number, and a whole variety of different things. Again, if you're going to exempt records, and then there's a series of other types of exemptions that are listed here. I won't read these all to you. You'll have them. You get the sort of the gist of what we're talking about. I think this one's interesting with infrastructure, security records, obviously with terrorism and things of that nature. We need to protect certain critical data from being made available. Persons under 18, if they might be, working in your recreation department, different things where you might have an employee under 18, certain things can be exempt as well. But as an individual, when the public comes in and wants to make a request and is asking for a public record, there is virtually no requirements that person has to provide to you. Clearly, they have to tell you what record that they're looking for. They must identify that record with a reasonable amount of clarity. It can't be overly ambiguous. However, there's a lot of entities will have a form, and you're asking the individual to fill out a form if they want to make a public records request. That's fine. In my entities and through my career, we had such a form. But if the individual refuses to fill that form out, you can't make them fill the form out. You cannot deny their request for a record based on the fact that they have not filled the form out. Generally, we explain to them the reason we're asking, you to fill out the form is so that we understand very specifically what record it is that you're looking for and how we can get that record to you in an expeditious manner. But you can't ask them to identify themselves. You can't certainly ask them, what do you need it for? What do you want that record for? Those are things that are prohibited or at least not required. I mean, if you're asking in a way that you're trying to assist them in the record, if they're really not sure they're after, so, well, what do you need it for? Maybe I can help you find the right record that you're looking for. But if a person knows what they want, but they don't want to tell you any of those things, you cannot require them to do so. There's also a major, this is probably the biggest one where I've seen public entities make a mistake, is that in the Ohio Public Records Act, there is no obligation for you to create a record which does not exist. And many times, at least in my career, we would have individuals come in, especially during some difficult or some hot political issues, and make requests for records that it certainly sounded like we should have, but believe it or not, there was actually no record that existed that documented what that particular individual was looking for. We may have had the information, and that information that the person was looking for may have existed had we put together 15 records or done the research and looked at 15 different records and pulled the information off of 15 different records. But there was no single record that produced that information. And some of it could be fairly basic things. I mean, we've had individuals say, well, I'd like to know, they were looking for a trend on budget spending. And they wanted to say, I want to know how much money you spent on police beginning in 1984 to present day. And I want to know what the budget was for your police department in each one of those years. Well, we could have given them the police department budget, the full budget, but they were looking for is, I just want to know total amount for these, for some period of time. Well, we didn't have such a document. it would have been fairly easy for me to get that information to them, but there was no single document that actually documented that information that they were requesting. Believe it or not, there was salary information. We didn't have one sheet that had every single employee of our community's salary. Certainly that information was in our UAN system. It was in our finance system. It was in various records, but there wasn't a single document that did that. And so do not create that document, even if you're trying to be helpful, because once you do that, A, you've created another public record, and B, you've now demonstrated that if an individual comes in and asks for information, you're going to create that document for them, and thereby setting a precedent that, you know, for the next person, you've said, this is something we generally will do. So be very, very careful about that, about creating those types of records. If you're going to deny a record, someone asks for a public record either in writing or they've done so verbally, and you're eventually going to say, nope, we're not going to provide that, or you're going to give them a partial version of that record. In other words, you're going to provide the record, but you're going to redact. You're going to black out certain information. For instance, I'd like to see a personnel file of, you know, one of your employees who happens to be a police officer or firefighter. Well, by law, you're required to redact that information, certain information related to their personal, certain personal things, as we've talked about, that are exempt. So when you black that out, you have to notify the requester of why you have blacked it out, why you have made certain redactions, or why you've withheld a record. In many cases, the standard thing that we would say, as I explained, if we had a requester who was asking for a document that we didn't have, we would simply respond, there is no record in our possession that can comply with your request. And again, depending on who the individual is, in most cases, you're trying to be helpful, but you have to be careful in that particular area. And as you get public records requests, again, this is something you need to be familiar with the policy to make sure that individuals in your office, that's in your administration, are aware of what the requirements are. Most of you as council members, this isn't something you're not going to be, in most cases, maybe except for the mayor, you're probably not going to be the person that is providing a public record to a requester. It's going to be an administration function, but it's still good to know what you're doing, and then know as a council member, anything that you're doing that's documenting official business of the village, you are and can be creating public records, and you need to be aware of those when they're in your particular possession and have a procedure for that. Again, you know, these sort of go across the gamut as far as what the penalties are. This has calmed down a little bit, I think, in recent years. Boy, about 8 to 10 years ago, this was a fairly problematic area for a lot of local governments. And if any of you know, there was a local attorney around the Cincinnati area. I'm thinking this was probably 8 to 10 years ago. I won't name him by name, but he made a living out of making requests, public records requests to entities that he felt pretty confident they wouldn't comply with. In most cases, his requests were fairly voluminous, and they were complicated. But he knew what he was doing, and he knew the entity had the record, but most of them wouldn't be familiar with the procedure or wouldn't know how to comply in a timely manner. And as you can see, in most of these cases, he was awarded attorney fees. And this is the only thing he was doing. He was basically looking for records, and then he would sue you. And in the courts, he would get his attorney fees awarded. So he wasn't even necessarily interested in the penalties. In certain cases, penalties were also administered, but he was living on attorney fees, and that's all he was doing. He didn't even want the records that he was requesting. In fact, most cases, he didn't even come to the office to ever pick them up. He just was trying to catch, when you eventually did produce them. So this is, like I said, can be an area, can be very, very problematic. And, there can be statutory damages that are awarded. And you can see that, they can be $100 a day per business day. So can be fairly problematic and troublesome type of penalties if you're not acting in the proper way. Okay, we're going to move into the third and the final piece of the statutes in Ohio law to ensure open government, and that is the Ohio Open Meetings Act. The first component of this act is that public bodies must take actions and conduct all their deliberations upon official business in a public meeting. Pretty straightforward that when you're having council meetings, when you're taking official actions, again, of the public body, so this is council, this is whatever legislative body is in place. So whether it's city council, whether it's village council, whether it's a township board of trustees, whether it's county commissioners, these are the public bodies that we're talking about. And they have to, all of your deliberations, all of your official actions take place during that meeting. Again, there's going to be some exemptions that we're going to talk about. The second major component to this is that you must give notice. The public must know when you are meeting, both the time, the date, and obviously the location of where this public meeting, and that has to be done in advance. And there's a procedure by which you go through and can do that. And then the third component of the Open Meetings Act is you have to document what you do. Your meeting minutes are required so that I can come back and view previous council meeting. When I say view, I can view at least the minutes. Maybe you have them on tape. Maybe you keep those tapes. A lot of public entities do that. They have that available. That's not required, even if you're doing it, but you must keep the paper written minutes of the meeting, which are available to the public. And I would tell you, going back to the Public Records Act, and as we talked about, this is one that is a simple, a basic type of document that every public entity should be able to produce almost on demand. Again, it might be, if I come in the day after your meeting and want to see the minutes, well, of course, they won't have been prepared in most cases by then, but in a reasonable time, and certainly at least when you have your next meeting. So in other words, if you're meeting in March, by your April meeting, most bodies are approving their minutes as the first order of business. And so that should be made available. So the first thing is, what is that public meeting? And as we talked in the very beginning, this has been in the news quite a bit. The Sunshine Law, you've heard of, a lot of times referred to as the Sunshine Act or the Sunshine Law. And we know some council members of the city of Cincinnati got in a lot of trouble for this particular issue and got a lot of bad publicity over this. But remember that a meeting is a prearranged gathering of the majority of the members of the public body. And again, that purpose is that you're discussing some form of public business. So if 5 members of Lincoln Heights Village Council decide to get together and have coffee, is it a public meeting? If all you're discussing is personal business, it is not. If 2 of you get together, certainly not, because it wouldn't have been a majority. But you need to be very, very careful on this particular issue for a couple of reasons. One is purely the optics of it. If 5 members of council are getting together on a personal getting together every Saturday for breakfast or whatever the case may be, you need to be very careful of what that looks like. And you say, well, we weren't talking about public business. Well, you probably, maybe when it was scheduled, you weren't thinking about it. But if 5 of you are together, the fact that you don't mention something about what's going on in Lincoln Heights during that discussion is pretty inevitable. It's probably going to happen. And then technically, you will have violated the Public Meetings Act or the Sunshine Law, because that constitutes a meeting. As you can see there, it doesn't, the things that it does not include, this can be a problem. We get this question all the time as well. What if 3 or 4 of us, attend a conference together? Well, as long as you're not discussing village business in a very specific way, it's not going to be an issue. I had the issue. I've worked in township government for many, many years. And with only 3 elected officials or 3 legislative elected officials with my trustees, it only took 2 of them to be together before you had the potential for a conflict. So again, use common sense here. The best practice is to err on the side of avoiding being together. I've worked with boards that were very, very close to one another. They became good personal friends. That certainly isn't a problem, but you need to be very, very careful about what the perception looks like. And then also the fact that, if you are together, are you likely to talk about township business or, public business? And the answer is yes. It's very difficult. It's very difficult not to. There are exceptions. You hopefully are very familiar with an executive session, and this is the part of the Ohio Public Meetings Act and statute, or the Sunshine Law, which gives you specific authority to meet sort of behind closed doors. So you could be in the middle of a council meeting, you can declare a public or declare an executive session. There's a motion to go into executive session, but it can only be for these items listed and no other. And you have to be very, very, very specific that when you as a public body are moving into executive session, that you articulate which of these reasons that you are going into executive session for. In that executive session, there are no actions taken during executive sessions. They are purely discussion. So as you meet to discuss these items, any of these, whether it's an employment matter, whether it's to continue, or to discuss the purchase of property, or whether you're talking about pending or imminent court action, certainly bargaining sessions. I know as a village, that's not something you're required to do, but some villages still have bargaining sessions with unionized elements of their workforce. Certainly you can do that in executive session. Anything that you feel absolutely has to be kept confidential to protect the public interest can qualify. Security arrangements, and then again, confidential information if you're related to an economic development assistance or purchasing again a property or something. These are the areas, but you want to identify which of the reasons, and then whatever that topic is, it's discussion only. If there's action that needs to be taken based on your discussion, that then has to take place. You have to reconvene back into open portion of your meeting, and the action would take place there. So discussions only in executive sessions. And going into executive session is also procedurally, you need to make sure that you're doing that in the right way. Again, there needs to be a motion specifically stating the statutorily approved section and the reason why you're doing that. And then unlike most other motions, the vote on that particular motion should be done by roll call. So it's not just all in favor like you would typically act in many cases on motions. This is one which you're going to have a very specific roll call. to ensure there's a quorum. The other piece of the Open Meetings Act, and not going to spend a whole lot of time on this one, but that is the meeting notification. And there's a process to go through, and keep in mind you have different types of meetings. And again, your charter can address this or may address this specifically as well. In general, your charter cannot be less prohibitive than what state statute is, but it certainly can be more. So you may have more onerous meeting notifications because it's in your charter, but these are sort of the minimums. And regular meetings are going to, they're going to talk about, hey, we are going to meet on the second Tuesday of each month. And that meeting notice, traditionally in the entities that I were involved with, we would do that one time first of the year. I mean, we'd send out a notice to anybody that had requested that notice and to all of the media, and put that notice out that the board's going to meet at this time. Those are going to be our regular meetings. Once we've done that, we don't have to give additional notice unless there's going to be a deviation from it or a special meeting. And that would be the second type of item. And we may not know when those special meetings are going to be. So we need to make sure that when we're having a special meeting, we are going to give that notice to that same group of people who have asked for notification at least 24 hours. And then the last one is an emergency meeting. And that's something that's going to require, immediate notice, and you give that notice, and that's generally, it can be done less than that 24 hours. Wouldn't recommend that you use the emergency meeting provision unless you truly have an emergency, unless it's something that, any reasonable person is going to say, yeah, they really couldn't have, that they needed to meet, they needed to take action immediately, and they weren't just calling it an emergency meeting to avoid giving proper notice and keeping the public in the dark. Common sense will keep you out of trouble. It's as you try to, get around this law is where entities get themselves in a lot of trouble. Minute requirements, we talked about that a little bit in the beginning of this section, in that every public body must keep their minutes of their public meetings, and those minutes must be full and accurate. They're not transcriptions, they're not word for word, but they have to have the sufficient facts and information so that if I read them, having not been to your meeting, having not viewed your meeting, I can reasonably discern what took place in it, why, who spoke, what council members' comments were, and so forth. A lot of times the best thing, I've got a lot of background in zoning, and if you've ever been to a zoning case or any kind of land use case where the public's involved and it's somewhat controversial, you may have 100 people speak from the public in opposition to a particular development. Well, you want to list each one of those individuals who got up to speak, but inevitably, many of them say the same types of things. You don't have to capture every word that person said. You just want to say, Mrs. Jones, appeared, this is her address, and she spoke in opposition of the development regarding, she mentioned traffic and drainage. You don't have to get into word for word. She may have spoken for 10 minutes on the subject. You're just capturing the gist of what she has said. There are no minutes kept for executive sessions and those deliberations and discussion. There's minutes that indicate that the board or council went into executive session. It articulates what the reason was, but it does not talk about or list a summary of the discussions that took place. So be very, and also those discussions in executive are highly confidential. So they are not to be discussed with anyone other than the individuals who were in that executive session, and not to be talked about really to any other person, or you've avoided the or basically prohibited by the executive session. Again, we've talked about it. Minutes must be available to the public, and even before that they've officially be approved. So if you've written them and they haven't been approved by council, you can still make them available in a draft form. Just make sure that draft is stamped. Again, there are penalties and fairly high profile of what happened in the city of Cincinnati, which was basically they were texting each other and having text meetings, conducting business via text or by the phone. While they didn't personally receive these penalties, the city did, and it was fairly substantial. It's been fairly controversial as to why the city should have to pay for these council members knowingly violating the Open Public Meetings Act. Again, not going to read all of this to you, but know that there are penalties. So the final section, and then we'll open things up to questions that you have, is another not too exciting subject, but also very, very important one, and that is Ohio ethics law. And again, we're like we've done on each of these, just in the hour that we have this morning for these topics, we're going to hit pretty much at a high level. So there are basically 5 areas where Ohio ethics law prohibits, and the first one is conflict of interest. The second is having an unlawful interest in a public contract. Third talks about that confidential information. The last is nepotism. And then the fifth area is one that I'll talk about on a personal level because it affected me somewhat, and that's accepting certain types of employment either during, but more importantly, and one that a lot of people get in trouble with, is sort of after your term of office and what the Ohio public ethics law prohibits. So we'll talk first about the conflict of interest. A lot of these are pretty common sense, but it's amazing while they're common sense, they're really not common practice. And people get themselves in a whole bunch of trouble. And again, we're speaking of you as a public official. The Ohio Public Ethics Act was predominantly written for the elected official, but it certainly also applies to staff and employees of local government. But I will tell you that the target primarily is, unless somebody just does something really, really egregious, the target primarily is you as the elected official, the responsible person. So the first one is you should never, ever, ever solicit anything of value, accepting anything of value for what you do, for being that public official. And these things, with COVID, certainly we're not seeing a lot of this just take place right now, but you can see some of the examples. Probably the most common is tickets. Somebody wants to give you tickets to an event. They want to invite you to that event. And I think, the first thing, and we'll get into this a little bit, but there's really in Ohio, a lot of jurisdictions or a lot of states and their ethics conduct, they list a dollar amount and say, well, if it's under a certain dollar amount, that's okay, but it's over this dollar amount, then you can't. Ohio does not do that. There is no dollar amount listed. And so based on that, typically, and I know this sounds ridiculous, even a penny is something that you shouldn't be accepting. But as you do that, and you look into this, we always try to look at the practical aspect of this. I can read what the law says, but let's talk a little bit about the practical application of this. You have to consider the person that's giving you the gift. What is the source of this thing, and why are they giving it to you? And are they really expecting something in return? Many times, and I always joke that if somebody's offering you Bengal tickets, I don't know how anybody can say there's a value there. That's more of a penalty, right? I mean, who in the heck wants to go to a Bengal game over the last 10 or 15 years? That's sort of a bit of a penalty. I don't think anybody can see there's any value in that. And I'm being a little facetious, but certainly, you have to consider. And if somebody, if ICRC says, hey, we've got these tickets and they're available, does anybody at the village can use them? Well, ICRC isn't somebody, that's one of your partners that you're working with. So there's nothing they're trying to gain out of it. There's nothing they're looking for in your decision. So, but the rule of thumb is just be very, very careful if you're taking anything of value. The best practice is not to. That's going to keep you safe. The use of authority. Don't use your official position to get something. Good seats at the theater because you're the mayor or you're the police chief, or, oh, hey, this person's going to get something special, or a speeding ticket. You're a member of council, one of your police officers, either in your jurisdiction or a neighboring jurisdiction, pulls you over, and the first thing you say is, do you know who I am? I'm a council member, for the crying out loud. You can't give me a ticket. Very, very specifically in prohibition of ethics. Now, again, common sense says, if that officer chooses not to give you a ticket, that's their discretion. And most officers either would be thrilled to give you a ticket because that's the thing they're very excited about, or they'd be absolutely petrified to do so. But certainly don't use that official position to secure that. Supplemental compensation, again, very common sense. But what oftentimes happens, and this is probably the most problematic one that I've seen, is police officers, firefighters, public officials. Certainly during COVID, we've sort of looked at our first responders, and businesses oftentimes want to reward those individuals, or they want to show their appreciation. So if a police officer comes in, or a firefighter, or a public health official comes into their particular establishment, they want to give them a discount, or they want to give them a free meal. There's nothing nefarious there. That business owner isn't trying to garner any kind of favor from that public official. They're in many, many cases simply saying, hey, I want to show thanks for the job that you do under difficult circumstances. They're trying to show appreciation, but technically that is a violation of Ohio ethics law. And do I think somebody's going to go to jail over that, or you're going to see a serious fine? No, but it's not a great practice, and it's something you need to be very, very cognizant of. If it happens one time, not a big deal, right? But if officers are going to the same particular business because that's the only business in town that gives them a discount, that's a problem. And, there's examples of a police officer going to the same business to get a free cup of coffee, but he did it, over 20 years of his career. And you start adding that up, and now suddenly you've got a pretty substantial compensation. The idea here behind why this is a violation of ethics law is you are already being paid to provide that service. A police officer is receiving the compensation, or a firefighter or any public official they knew what they signed up for. That's part of their job. And so they shouldn't be getting extra things. But that certainly can be, one that from a practical standpoint can be a problem. So again, other areas, Ohio public ethics law certainly prohibiting officials from authorizing a public contract. So you grant a contract to a business in which you and or a family member has an associate or an associate that has an interest in. Very, very, that's straightforward, going to be a problem. Authorizing the investments of your funds, same thing, in which a family member or business associate or yourself has an interest and receives a fee is going to be prohibited. Profiting from a public contract of any kind is a no-no, and certainly having an interest in the profits and benefits of a public contract, all pretty similar type areas and actions. Be very careful about confidential information that you may come across in your capacity as a public official, as an elected official, and you hear this in confidence. Because of that position, you need to make sure that you're not disclosing that confidential information or using it in a way in which you are personally going to benefit. The most common area of this would probably be something related to property. You hear a property is going to become for sale, or there's a property interest and there's an opportunity, or obviously not so much in a stock or a bond in the public sector, but property is the one that and suddenly you take action to buy property or to get involved in a particular development on the ground level because you became aware of confidential information. So this is not only action, but also disclosing that. Nepotism. Ohio public ethics law prohibits officials from hiring family members. And these are family members, a spouse, parent, grandparent, child, doesn't matter where they live. You cannot hire them in your capacity as a public official. Now, that doesn't mean that somebody can't work for the village that you're related to, but you cannot be the person that's involved in that hiring, and you should recuse yourself. Family members who cannot be hired if they live in the same household, and you can see the list there, uncles, aunts, cousins, nieces, nephews, in-laws. If these are individuals that actually live in your household, they cannot be hired. Again, other types of, this is the last type of thing that we're really going to kind of get into is if you were involved, you're an elected official, and let's say your capacity as that council member, you are in charge to work with a very specific vendor. Maybe, for example, a lot of times I'll give a better example, the fire chief. Fire chiefs will be heavily involved if you're buying a piece of fire equipment. They're selecting the truck. Yes, it's a bid process, but ultimately that fire chief might select a particular manufacturer of a fire truck or a life squad. And to do their job correctly, they build a long-term relationship with that manufacturer because they're evaluating what's best for the village. And then when they have that piece of equipment, they're making sure it's warranty and they're dealing with that manufacturer. Well, let's assume that manufacturer, the chief's going to retire. That manufacturer said, boy, it sure would be great to have Chief Smith working for us and meeting with other fire chiefs to talk about what a great product it is. Well, he's leaving his capacity. He's retiring from the village of Lincoln Heights. Can he go to work for the Pierce fire truck manufacturing? And the answer is, in that case, no. There has to be, in most cases, a 2-year period, depending on what exactly it is, or at least 12 months separation before he can go to work. This is known as this revolving door. And again, it's this conflict of interest that this quote unquote deal was made before he retired. And the reason he selected that Pierce fire truck was because he knew that there could be employment down the road. Again, something that you need to be very, very aware of if you're taking a employment with a particular company or a vendor in which the city, village, township did business with over your career and that you were heavily involved. In my particular case, the example I told you is I was a board member as a township administrator. I was on the board of Ohio Plan for 22 years. When I retired from Springfield Township, I was offered the position to come work as the executive director. So even though the Ohio Plan is a nonprofit, even though we're owned by our members, it probably didn't qualify. Just to be on the safe side, I made sure there was a 12-month separation before I had any involvement as a board member in any capacity or involvement in my role as township administrator in our dealings with the Ohio Plan before I accepted the position. So again, probably not who they were going to come after and probably didn't even meet what this was really intending to do, but you want to err on the side of avoiding any particular problems down the road. We've talked, and you can read these in your leisure and won't spend a whole lot of time going in, but there are penalties to this. And in these penalties, the first thing I always want to say is the Ohio Ethics Department, the Ohio Public ethics law does not have a large staff. So they are not going to be doing, they'll eventually do these investigations, but they're not out there looking for you. How your behavior gets to them in most situations is that somebody reports it. And that somebody could be a colleague, that somebody could be a resident, anybody from the public. It could be one of your employees that see this. And all they have to do is file it with the Ohio Ethics Commission, and then it will be investigated. So the commission doesn't have investigators all over the place looking for this. They're not out there trying to police it, but it is sort of, it's reported by the public or anybody, and they will investigate every claim where somebody files an investigation. So there are eyes everywhere. Read these when you get the PowerPoint. They're pretty easy to stay out of trouble. They're pretty common sense. But what I find is a lot of times individuals, they have no intention to violate it and they unknowingly do it. But that's not going to be an excuse, right? As a public official, as an elected official, you have the obligation to understand all of these provisions that we've talked about here in the last hour and make sure that you're staying on the right side of them. Hopefully that was helpful. I will take a minute. I know we've gone just a little bit over, but I think we started just a few minutes late. But any questions that I can go to or answer for you?
Okay, anyone has questions? Thank you, Mr. Hennenkamp, as well. Okay, show of hands. Anyone have questions for him?
I do, Mayor.
Yes, ma'am, go ahead.
On the records retention, we do have a schedule, but it probably needs to be revised. So have there been any new guidelines published?
I would say, I haven't seen anything very, very specific. And I'm just going to that record schedule real quick. I'm not aware of anything that has really dramatically changed. I'm sure, there's always some modification, but I don't think there's anything critical that I'm aware of. But I think it's probably just a good idea to, almost on an annual basis. And it doesn't mean that you have to, start from scratch, obviously, but I think annually it's probably a good idea to have that as an action, that you're going to review. You're going to review your records retention schedule. You're going to take a look to see if there are any changes that need to be made, not only to it, but any changes in the law. But I'm not aware of anything specific at this point.
And what about storage of records? On-site, off-site?
It's again, there's pretty good discretion as to where you can do that, as long as you identify that in your records retention schedule, and as long as those records can be accessed in a reasonable time period. Especially if it's a physical record that I come into the office and I want to have I want to see a copy of that record, or I want to actually have I actually want to view the copy, or I want a physical copy. You can't say, well, we're going to have to, get that record from California because that's where we store it. That would be inappropriate. But as long as you've got a record that you can get, access to in a reasonable time period, doesn't, as long as it, contracted space or your physical space, I think there's some discretion as to where you have that. And the type of record obviously is going to matter as well.
Thank you.
Okay.
Yes,
All
ma'am.
right. I see Councilwoman Tanya Key has her hands up.
Thank you, Madam Mayor. Thank you, Mr. Hennenkamp. This was a great training. I do have a question about the open meetings. On one of your slides, you were showing regularly scheduled meetings, you showed special meetings, you showed emergency meetings. If you can go back to that one, I have a question about the regularly scheduled meetings. And this is as it pertains to the agenda for that particular meeting. Do we have to show publicly in advance the items or topics that are going to be discussed in that meeting? or is it okay we have the regularly scheduled meetings already set,
Mm-hmm.
been publicized, we put it out in our newsletter, so it's a regular occurring meeting, but sometimes we may not have agenda items on the actual agenda prior to the meeting. Are we in violation if we do that, or what would your recommendation be should that be the case?
There's to answer your question, no, you do not have to have that agenda for a regular meeting. I think that's going to generally identify the types of topics that could be dealt with during that regular meeting. Yeah, it's always a good idea to try to have the agenda prepared as far as advanced, but a lot of that's going to be sort of at your discretion as council, and maybe your charter may also address that specifically. I mean, some charters that I've seen are very prohibitive in the sense that the agenda must be complete and must be made available 24 hours or even in some cases longer, and that there can be no alterations to it without, a very specific other series of actions by council. But as long as your charter is silent, there's no provision that you have to have that agenda published ahead of time. Again, there's going to be certain types of actions. For instance, and I would say, let's assume as part of your regularly scheduled meeting, you're now going to have a public hearing within the confines of that regular meeting. And that public hearing is going to be on a very specific item. That's probably, while maybe not a violation of the Public Records Act, it's probably not good practice, because the public meeting, you're asking, anytime you say public hearing, you're talking about the ability for somebody to speak at that meeting. One misnomer is that everybody thinks that because you're having a public meeting, the public, get to speak in that meeting. Not necessarily true. Now, I don't hardly know any public bodies that don't allow for some public participation, but there's no requirement that you do that, except if it's a public hearing. And then there's a portion of that. So if you were to sort of spring that public hearing on folks without giving them any pre-notice, I'd probably be able to say, look, you didn't give proper notice. I wanted to come and speak on this issue. You're going to raise the income tax, and there wasn't any public conversation about that. I'll give you an example of an entity that got in trouble. Was the Village of Amelia, which has been dissolved. I don't know if you're familiar, but the Village of Amelia in Claremont County has had, they've had a long history of battles politically back and forth between these two different factions, but council was they had never had a income tax or an earnings tax, and by council, you can do that without the vote of the people up to 1%. And so they had public hearings on that, but they didn't announce any of them, and they did them all as emergencies because they didn't want to hear, any feedback from it. So it became problematic. And while I don't believe they got in violation of the Public Records Act, it certainly caused other issues and eventually led to a petition to dissolve the village, which happened about a year and a half ago. So, but to answer your question, I think you're fine with, you can add things, again, whatever the rules of council are, but not necessarily put you in violation of Public Records Act or Open Meetings Act, rather.
Thank you. And Madam Mayor, I have one more question if no one else did.
I don't see any other hands. Yeah, go ahead.
Thank you, Madam Mayor. So my next question pertains to executive sessions or things that are confidential. Being as though we're in the virtual world right now and we're doing our meetings remotely, do you have any recommendations or do you have any thoughts that you can add to how we as council or individuals who might be in those sessions should act so that we can protect ourselves to keep that conversations confidential? And the reason why I'm stating that is because we are virtual, so we can do mobile we can move, we could be on our cell phones, we can be in different areas, we could even be in our homes where others might be privy to hearing the conversation. What would be some of your recommendations on how to keep that information confidential?
Yeah, that's a great question. I mean, certainly a new world, right? And there have been quite a bit of exemptions where the states allowed, meetings to take place in ways which probably none of us could have dreamed would be possible a few years ago. I don't have anything specific. I think what you just mentioned, I think best you can, if you know in advance that there's going to be an executive session or wherever you are during that meeting time, take steps to ensure that you're at a quiet place. Take steps at a place where you're not going to have your kids. I know that's not always possible, but for the most part, these meetings are going to be scheduled. They're going to be prearranged. And, to your point, it's wonderful that we have technology that allows us to do things mobile and be on the run. But on the other hand, that you're right, that does oftentimes allow for the background to either annoy the other participants of what's coming in, or also allow somebody to hear something they shouldn't. So I think the best practice is just to schedule it best you can, like it's almost like like you're going to council, but find that spot in your house or your office or wherever the case may be, and do it. I mean, case in point, I've got, I came into the office to do this session, and there's a bunch of reasons for that because it's a more comfortable setting than in my home. But, I've got two 20-year-old twins, and who knows who's going to pop in where or what's going on, or the dog's going to be yapping, or somebody's going to come to the door. And all of those things obviously can be a distraction, but, in a different circumstance, as you mentioned, somebody hearing it. So I would practice. I think it's a great question. I would just make a point of being in a specific quiet place where I, can assure that there's not going to be eavesdropping and there's not going to be a lot of background noise and distractions.
Thank you.
Is there any other questions? Looking for hands. Oh, okay. Councilman Daniels, I see your hand. Go ahead.
I just had thank you again. Great presentation, gave a lot of clarity on a lot of things. I'm trying to get my hand come back down, but
thank you.
Just a question on just the conflict of interest piece, and just for clarity on a couple of different issues, and I'll be frank, and just so it's as transparent as possible. I'm a part of a group. I'm a member of an organization that is a nonprofit organization that works here in the village. What the goal is really is, you're engaging and you're talking to people and doing things of that nature. When it comes to working with the village, now myself, when it comes to working with the village, I'm a council member. Well, let's just say I'm also a member of this organization. When it seemed, and when we asked our solicitor, it particularly talked about your board, like if you're a nonprofit organization, your board is the one that really kind of has, because they're the ones that have those type of decisions and those kind of, weighing factors. As a member of that organization, I guess what I'm asking, am I allowed to attend meetings that pertain both with the village and that organization? For example, I'll give an example. There's a foundation started by the Obama Foundation called My Brother's Keeper. So our organization oversees and pretty much are the drivers of My Brother's Keeper here in Lincoln Heights. Lincoln Heights has taken on the My Brother's Keeper Challenge, and we passed it in a resolution. There are meetings there are some alignments within My Brother's Keeper milestones that pertains to, second chances and working with our young men, making sure that they do certain things of that nature. So as a council member, once again, I'm on our law committee, and so I don't really deal with, in that end of our police in that sense, but I'm still a council member. From our organizational standpoint, I don't deal with like, that's not my lane, that's not what I drive, but it's still a part of our organization I'm a member of. Like, so am I even allowed, like, can I go to those meetings and then from those meetings bring resources or information back to our village? Like, are those things allowed? Because it's kind of been like, I guess there's been a lot of we want to make sure that we're clear on a lot of different things. And that's just one scenario where there's been questions of, well, Mr. Daniels, you're a council member, you can't now represent the Heights movement separately in some instances. And I'm just trying to make sure if that question makes sense. And I know it kind of seems like I was rambling a little bit, but I was trying to kind of give it a clear scenario, because when the instances that you put on a conflict of interest, like for instance, all those type of things, we're not asking, nobody is receiving any value, nobody's receiving any benefits, nobody's receiving any type of compensation, but the benefit goes to the village, right? So if you have an opportunity to bring within My Brother's Keeper, there are different type of partners that want to partner with My Brother's Keeper. For instance, so if you bring those partners and those stakeholders to the village, that boosts the village up. But not necessarily My Brother's Keeper is boosting up the village. But I guess there's some instances where they're saying, well, not necessarily they're saying, but there's some instances where there might be some confusion that if you are a council member and you also represent My Brother's Keeper and you bring that information back to the village and that now passes, obviously you don't vote on it, of course, but if that now passes, that could be a conflict of interest.
Yeah, I mean, in without knowing all the details, but just based on the way you've described it, I didn't hear anything that would give me reason to believe there was a conflict. I completely understand without knowing the intricacies of those particular organizations that you're talking about, but certainly there's a lot of things in which you're dealing with. There's common interest, right?
Yeah.
And the fact that it's nonprofit and so forth, and that you're not benefiting personally from these things, it's the village, it's the organization. You have common mission, you have common values that you're trying to achieve. So I certainly didn't hear anything in what you said that would lead me to believe there's conflict. I think the key thing, and it sounds like you've done it, is one is disclosure. There's always, I mean, that's number one, is that on any time that you feel uncomfortable or you feel like, well, wait a minute, is there a conflict, or is this at least going to be perceived by the public, or someone is maybe not meeting the smell test. So in that meeting, before you take any type of action, you're simply disclosing it. Hey, as everybody knows, I'm a member of this organization, and this is, and you're explaining the rationale behind your action or your vote. And then if there ever becomes a time where there is a vote related, something that you've got knowledge of, or something where you're going to vote on council that's going to benefit this organization, even though it's going to benefit council as well, and you're not comfortable, you can always recuse yourself. But I think the key is just being very transparent about it, and putting that on the record best you can. But I certainly didn't hear anything that would have given me, again, just based on what you've explained it certainly doesn't sound like there's a conflict, is at least what the ethics law is looking at. But this is the point of it all, right? And I would applaud you for just bringing the question up, because that identifies that you're thinking about it, and that's part of it.
Okay, so Mike, I have a question to ask.
Yes, ma'am.
What Mr. Councilman Daniels, he had a good question he wanted that he asked you, but he's also the executive director, and some information was not disclosed to council till after the fact. So that's why we needed clarity on that as well. When they
absolutely,
director.
And I think that's what you want to do, is you always just want to, like I said, you want to disclose and be as transparent and forthcoming with all of the information. And then, like I said, if you feel comfortable personally you take the appropriate action. If you don't, the recusal is always, I mean, I've had elected officials that have, were attorneys, and they had an action, and then somebody came up and they said, okay, this company's coming up to ask to do something in front of the township. I have represented this company in the past. It's a totally unrelated matter. I don't have a conflict here on this particular situation, but for the purposes of appearance, I'm going to recuse myself from this vote. That's the safest way to do it.
Yeah.
And, but where you truly don't have a conflict and there's no, there's no negative. Yeah, it's kind of up to your discretion, but, they're gray issues. I mean, there's no question there's gray issues, and the easiest way is to recuse.
Yeah.
And explain it and just say, even though I'm probably perfectly okay, I'm not self-interested in this particular issue, but just to avoid any potential, or at least the perception, I'm going to recuse myself from taking any action. And the key thing is on a recusal, depending on the technicality, you really should leave the room, and you certainly shouldn't be a part of all the the conversation and the dialogue and then just not vote. You should either leave while that particular item of the agenda is being discussed. If you're going to not vote, you probably shouldn't even be in the room.
Yeah.
Because otherwise somebody could say, well, you didn't vote, but you're influencing them, you're pressuring them, your body language, your eye contact. And again, I'm not saying that in this particular situation, but in others that can be the case.
Yeah.
I have a question, Mayor.
Yes, Vice Mayor.
So you saying if they should leave the meeting totally if it's something that they are going to recuse themselves from?
That's
Just
your
because
best.
of their body language might sway somebody?
Well, I'm using an extreme example.
So to me, that's saying that even if I don't speak and I don't say anything and I don't vote, I got to leave the room?
Well, I mean, again, depending on the particular situation. I mean, in cases where I've seen there's a conflict of interest and the person says, okay, I know I've got that's, whatever the issue is. Let's say there's a development proposal and you have some interest in that particular company that's proposing this particular development. You've got stocks or you've got family member, whatever the case may be, there's some interest in that development company. And it's coming up for a vote. And you've got, council is going to approve it. The gist is that everybody, there seems to be no opposition among council. This thing is going to get approved, but there's some controversy in the community, right? So that you've got an element of the community that is there in opposition to it. And throughout the very end, it comes your time to state your feelings on the matter, and you say, well, I just want to disclose that, I've got an interest in this particular development, so forth, so on, and I won't be voting. I'm going to recuse myself from vote. That opposition party could say, Vice Mayor Stenson didn't vote and it still passed. However, she had influence because she engaged in the conversation throughout the meeting, and her influence may have, the other members of council may have voted for it because they didn't want to make her upset. If you're not going to vote, you should probably identify as soon as the hearing starts, you should make that statement that I won't be voting. I will not be participating. In fact, I'm going to remove myself from the room, and I'm not going to even be in here as you discuss this matter. I'm going to go into an office, and when this when this agenda item is over, I'll resume my spot. That's the cleanest. I'm not saying by not doing that, you're in conflict of interest by any stretch of the imagination. I mean, each of these cases are evaluated individually, and the specific fact pattern is going to matter pretty dramatically. So please don't say that on every issue you're not going to vote, you have to leave the room. But on certain situations, if you know it's going to be controversial and you want to protect the village and you want to protect yourself, that's going to be your best practice. Again, depending on what the particular agenda item is. With Councilmember Daniel's situation, I don't know that that would certainly be necessary there, but that's the best practice. That's the cleanest, easiest way to avoid any appearance of conflict.
Mike, I have a question. So what is
Yes,
the
ma'am.
severity if, let's say, if there was a conflict of interest and they did not recuse themselves, they went on and tried to vote? Have you seen that happen in the past?
Oh yeah, I mean, you know, in the range of penalties depending on the investigation, it can be, you know, something like that. Depending on what the issue is, it can go far deeper than just the Ohio Ethics Commission might be the least of your problems, right? There could be all kinds of legal issues. I mean, the case of, you know, I hate to keep going down south to Cincinnati, but they've provided a lot of material for us in the last few years. And you can see where, you know, for Denard and PJ Sittenfeld and Pastor, I mean, those individuals, they're facing criminal investigations. They're facing jail time, you know. So the Ohio Ethics Commission was the least of their problems because not only did they violate ethics law, they violated federal law on all kinds of different issues. So rather than say there's going to be a blanket fine of $1,000, it's going to really vary depending on a lot of different factors. And, you know, it's going to depend on, you know, I hate to say it, but it's going to depend on the severity of what the issue is or what the political interest is in something. I mean, I've seen members do very egregious things and sort of nothing happens to them. You know, they get a slap on the wrist. And then you've seen other situations because of the politics in a particular situation where, you know, there's a lot more onerous penalties involved. So hard to give you just a general thing, but the rule of thumb is, you know, just by, and I think, Mayor, you and I talked, I would applaud you all for giving up a portion of your Saturday to do this. You're having the right discussions, and by having the discussions and asking the questions, that's 90% the way there. And then just use really good common sense and try to practice, you know, by looking at what I'm going to send you, and certainly you can dive deeper into these things. You'll do the right thing, and you'll know when this doesn't feel right, this is inappropriate, and I'm going to recuse myself or to avoid it.
We got one more question from Vice Mayor Stinson.
Okay, this goes back to what Councilwoman Key said, that asking the question about the agenda. If you have the agenda and you know what's going to be on the agenda, you would know if you would need to leave the room or recuse yourself. So I can see now that makes sense why that agenda is so important to have ahead of time. Because if you have it ahead of time, you might want to call whoever, the mayor, well, this is what's going to happen during this time. So nobody thinks that you're just leaving the meeting, I don't know, just to be leaving.
Yeah.
So that was a good point, Ms. Key. That puts that together.
And always the key is to just articulate it, be transparent, you know, on the record, say, this is what's going on. This is why I'm not going to be participating. And like I said, I've seen probably 9 times out of 10, the individual board member said, I don't have a conflict. I really don't have an interest, but this doesn't look right and it doesn't feel right. And I don't want to do damage, to myself, and certainly want to damage the reputation of our entity that something's underhanded. So to be extremely conservative, I'm going to recuse myself and remove myself from this discussion. And no one's ever going to, give you a hard time about that when you make it perfectly clear. But on the other hand, like I said, it doesn't mean that, every little thing you should not be sitting on. It's your own conscience to a big degree. And certainly if you have, I think where we've seen difficult issues is here, boy, we don't know that we've got the votes if I recuse myself. in a case. And again, I came from township government. A big part of my career was in township government. So if one member recuses himself, you only have 2 left to vote. So it takes both of them. And if the 2 don't get along, that can be an issue. So we've had, it hasn't come up often in my career, but I've seen individuals that should have recused that didn't, and folks that did that probably really didn't need to, but it's an individual choice. And no one really can make that for you other than you. And if you don't, you might subject yourself to some issues, but if you do, you got some other things. So can be some difficult things, but certainly if you know something's on the agenda, review it with your solicitor, have that conversation ahead of time, and try to do what's in your best interest and in the best interest of the village.
Okay. Well, thank you very much, Mike. We appreciate that you come with the information that you gave us for the Ohio plan. So we're getting a little bit behind. So that's why
yes, we are. I hope I didn't get you off track again. Thank you very much for the opportunity to speak with you. I wish we could do this in person, and hopefully we won't be too far from that. And certainly if there's any questions, feel free to reach out to me. I will send the information to you, Mayor, so you will have this PowerPoint, and feel free to distribute it. And if there's any questions or way we can be of help, love to talk to you. And again, I really applaud you all for doing this.
Okay, thank you. And I definitely will get that forward to council when I get that. Thank you so much. And let's continue in the near future.
Thank you. Good luck on the rest of your day.
Okay,
take care. Bye.
All right. Okay. All right. So we have our next speaker is going to be Miss Stephanie York, Esquire from Hennis Communications. And the topic is going to be social media crisis training. Hello, Miss York. How are you?
Oh. I'm well, thank you. That was an interesting last part of that discussion. I was an attorney for the city of Akron for 23 plus years, for the mayor. And so I dealt with city council and people recusing and not recusing when they should have and shouldn't have and all that. So that he's really right on point with that. Right. So very interesting.
All right. So the floor is yours, Miss Gigi. Can you, are you ready to share this? So you're going to be doing a PowerPoint, right?
I am. I'm going to pull it up right now.
Okay.
Can you see that?
Yes, ma'am.
Awesome. So a little over a year ago, I noticed that a reporter for the St. Paul Pioneer Press took to Twitter to criticize a Minneapolis city council member who had blocked reporters from following her Twitter account. Fred Mello, the St. Paul reporter, posted this on Twitter. I still can't believe the only elected official to block me, to my knowledge, is a local city council member who also blocks St. Louis Tribune reporters. She calls it a personal account, but still uses it to advocate policy, peak anti-transparency. And this prompted others on Twitter to weigh in on how they'd been wronged by elected officials on social media. That afternoon, just hours later, the Minneapolis Star-Tribune broke a story that said that the city of Minneapolis wants to rein in the online behavior of elected officials, proposing the mayor and council members begin using city-approved social media accounts that prohibit them from blocking constituents. And of course, the newspaper had a copy of the draft policy. This wasn't even the final one, and they put it online. I use this anecdote for a couple of reasons. First, I think it illustrates how much scrutiny the social media accounts of elected officials are getting. Second, I think it shows the speed at which issues arise. I mean, it was posted in the morning. By the afternoon, the city of Minneapolis was proposing a social media policy to prevent social media abuses by their council people. That's what social media does. And I think it shows you are all really in uncharted territory. Nationally, this has played out the same. That same year, a federal appeals court ruled that former President Trump had been violating the Constitution by blocking people from his Twitter account because he used the account to conduct government business and therefore could not exclude some Americans from reading his posts. Similarly, that same year, a federal appeals court ruled that an elected official in Virginia violated the First Amendment when she temporarily blocked a constituent on Facebook. The Washington Post called it a novel case with implications for how government officials nationwide interact with constituents on social media. The official, in a separate court filing, contended that her account was on a privately owned digital platform like Facebook. It was personal, and she should be able to restrict who gets a chance to speak there without crossing constitutional lines. In this case, she considered a community activist post on her site to be slanderous. This is just the tip of the iceberg. But one thing is becoming clear. Public officials who increasingly use social media accounts as public forums to foster speech and debate among their constituents have no greater license to suppress dissent online than they do offline in person. These examples specifically speak to the issue of blocking or limiting contact to social media sites. But there's much more tied up on the issue of elected officials and social media. Can an elected official really maintain a private or personal social media account? Is somebody talking?
Oh, I'm sorry.
That's okay. What are the implications for public records law? I know you just talked about public records law with the attorney previously. What are implications for retention of public records, social media posts specifically? What are the implications for sunshine laws that apply to public meetings? How do you properly distinguish personal accounts from campaign accounts from official village council accounts?
Excuse me, Ms.
Yes.
York. I'm
Yes.
sorry. Are you forwarding through your slides? Because we're stuck on slide 3.
Yeah, no, I haven't forwarded again.
Okay, I'm sorry. All right, because I'm listening and
okay.
I'm engaging and I hear you clicking. I didn't know if you had a slide.
Yeah, no, I'm clicking my notes.
Okay,
So.
okay. I'm sorry.
I'm good, but I do need notes to look at. I'm not that good.
It's really good so far. Thank you.
Social media isn't a technology, it's an enduring cultural shift. So I'd argue that you'll do yourself and your constituents a disservice if you ignore social media. So I'm here today to help you understand the influence of social media. I'm here so that you can grow your social media presence in a positive way, to help you consider how to use social media effectively to help your village, and to share with you some guidelines that we use in our work for all social media users, and some that we think specifically apply to elected officials. And while we started with the dark side of social media, we're not saying don't use social media. In fact, we'd say you don't really have a choice. Social media is not becoming less relevant as time goes on. So amidst all the change, we believe the fundamental rules of effective crisis communication still apply to social media. It's this simple. In the modern world of social media, your reputation is more vulnerable than it has ever been. Now I'm switching the slide. So there are dozens of reasons your reputation and the reputation of your village could be called into question and subjected to intense scrutiny. And just as many reasons why a reporter may stick a microphone in your face to talk to you about something you don't know anything about or you don't want to talk about. For example, you could have embezzlement by an employee, fiscal mismanagement. You face a sex or age discrimination lawsuit. You have a data breach exposing constituents' sensitive information, workplace violence, leadership conflicts. A colleague says something politically insensitive or outright racist or sexist. An active shooter. The list is endless. And any one of these situations could turn into an immediate crisis and go viral online. So with all that as a backdrop, and to help you control the court of public opinion, we use something called the Damage Control Playbook. And it has just 5 simple concepts. I'm going to teach these to you so you know what you can do in a crisis. And this is how you deal with a crisis with mainstream reporters, with your constituents, and on social media. So these Damage Control Playbook is for all those situations. If you learn the first 3, you'll be really good crisis communicator. If you learn the first 4, you'll be excellent. If you learn the 5 of them, you could do my job. Not that you would want it. So number 1, tell the truth. Tell the truth, tell the truth, tell the truth. Why? Because the truth always comes out. It may not be today, it might not be tomorrow, it might not be for 3 years when the court case is over. But if it comes out and they find out you've lied, you've damaged your reputation going forward as well as going backwards. And the corollary to that is don't deny the obvious. If the media has this much of the story, they're gonna get the rest of the story, and you're not smart enough to spin your way out of that. Rule number 2, tell it first. Typically, the person who tells the story first determines the trajectory of the story. And number 3, tell it all. We beg our clients, tell everything you are legally, morally, and ethically able to tell. Because if you're not telling it all, someone else is telling their version of all, which may or may not be true. And again, all you're doing is playing catch up then. I'm going to give you an example of this. I got a call from a law director of a small city just outside of Cleveland. Says, you got to get out here right away. I went out there. It was a big HR problem. Big. They were going to fire someone, right? So I asked him, what do you want us to do? He goes, I want to make sure this doesn't end up on the front page of the paper. I said, okay, here's what we're going to do. We're going to call the reporter that covers City Hall, because there's always one that covers your city, your village, your township. We're going to have that reporter come in. We're going to give them the story. We're going to give them the personnel file before they ask of the person that you're going to fire. We're going to redact what we need to redact, social security numbers, addresses, things like that. But we're going to give them the entire story. The law director looked at me like I was crazy. He said, we're going to do what? And I repeated it. And he says, I can't do that. That goes against everything I learned in law school. In law school, we learned you don't give bad information until it's discovered, until you ask the right question and we are forced to give the answer. I said, well, you were schooled in the court of law. I was schooled in the court of public opinion. If we do it your way, we will end up on the front page of the paper. If you do it my way, the worst thing that happens is we end up on the front page of the paper. The best thing that happens is we're not in there at all. He says, okay, I'm nervous, but I'll give it a try. Call the reporter in, gave him the story. Next day, I go out to the Plain Dealer, Cleveland Plain Dealer. Nothing on A1, A2, A3, nothing in the front page, nothing on the local section, B1, B2, B3. Nothing in the paper. Day 2, nothing in the paper. Day 3, day 4, day 5, day 6, day 7, day 8. Day 9, it showed up. It showed up all right. It was B11, bottom of the fold, 3 tiny paragraphs. I'll tell you, when this story comes up, even in the city where it happened, people don't remember it because we told the truth, we told it all, we told it first. If you think about the way reporters think, if it's not leaked to them by an angry ex-employee, if it's not given to them by a disgruntled PTA mom, if the reporter doesn't have to dig it out like they're pulling teeth from you, it doesn't seem to have the same importance. If you just give them the story, they're like, okay. Similar story, completely different result. I get a call from a executive director of a large nonprofit. Calls me up and says, we have 2 employees that embezzled over $1 million. I said, whoa. That's a big story. What do you want us to do? Because, everybody has a different end game on what they want in these situations. He said, and I'll never forget this, he says, I want to make sure the media never finds out. I said, okay, how many employees do you have? He goes, how many employees know about this? He says, about 23. I said, 23, you're not going to keep this out of the paper. They're probably already writing the story. I said, so here's what we're going to do. I gave him similar advice. I said, we're going to pick up a reporter we know and trust. I'll take fair over slanted any day of the week. We're going to go to that reporter. We're going to give them the personnel files. We're going to redact again what we need to redact, but we're going to give them the news. He says, I can't do that. I'll look stupid. I said, how are you going to look when the investigative reporter's outside your organization going, your tax dollars squandered, news at 6? I said, you're going to look horrible. He's like, all right, let's do it. Went in, gave him the story. This is not like the last story. I go out to the paper the next day. It's B1, top of the fold, giant headline. I mean, giant, just slightly smaller than Man Walks on Moon. It was huge, but it was a good headline. It says, agency discovers loss, takes action. It was a good headline. It was a good story. This stuff works. Tell the truth, tell it all, tell it first. They don't think you're hiding something if you do it that way. Rule number 4, and the reason I'm really here, tell it fast. The internet has changed many things, especially the relationship between TV news reporters and newspaper and print reporters. After all, up until like 5 to 7 years ago, who broke news? TV broke news, because if it was in the paper, when did it happen? By definition, it happened yesterday, right? So nowadays, every reporter is told, you don't leave that council meeting until you tweet something. You don't leave that school board meeting until you put something up on Facebook. And they're not just competing with other reporters. They're competing with your own constituents and employees who whip out their cell phones at a moment's notice, take pictures, tweet things about what's going on at the meeting. And this has given rise to something we call iterative journalism. And it's the biggest thing you've never heard of. And the way this works is I call 3 of you up because you're part of my story. So let's say it's Tanya, Ruby, and Jeannie. I call you 3 up and I will wait. The way it used to happen is I would wait all day for you guys to call me back. If you didn't call me back, I'd try in the afternoon. If you still didn't call me back, I'd go out to your work the next day. I'd go to your home. I mean, but if I went to my editor, he'd say, you can't write that story until you get their version of it. We don't have a story. But nowadays, I call you 3 up, you got 10 minutes to call me back. You don't call me back, I'm posting it on ohio.com or cleveland.com, right? It's going up. So I put it up there and Tanya, you see it and you go, oh my gosh, they got this wrong, and this wrong. You call me up and say, hey, you need to fix this. I'm happy to fix it. The story has a new iteration. And then Mayor, you call me up and you say, well, you know, respectfully, Councilwoman Key got to say something, but I didn't get to tell, you know, the other side of the story. I'd like to tell that. I'm happy to change it. It has a new iteration. And Vice Mayor, you call me up. You've been in meetings all day because you're a busy woman, right? You've been in meetings. You didn't get the message. It's been hours, right? You call me up. The problem is it's been hours since I made that call. The story has had many different iterations online. And here's the problem. Where do people read their news these days? On their cell phones. How many times after you read a story do you go back and read it again? Never. Unless you're part of that story and then you're like obsessively looking at it. But other than that, you don't go back, right? So if you waited all day to respond, if you call that reporter up, nobody's going to read your version and hear your words. So I suggest if you've gotten to that point and you do have very good information, you tell that reporter you want a new story and a new headline. It starts the process all over again. And you probably will get it because reporters these days are paid by the story, they're paid by the click and things like that. So I suggest you do that. And where is the court of public opinion first convened these days? Well, I've kind of talked about it on Facebook, on Twitter, on Instagram, on Snapchat, right? So when an issue or crisis hits, you need to be prepared for the first round of social media. So a May 2019 Pew study reported that 67% of US adults get their news on social media. 67%. They don't get it from TV. They don't get it from radio. They don't get it from reading the paper. They get it from social media. That went from 0 to 67% in 5 to 7 years. And that stat was 2 years ago. So you know it's only gone up. In breaking news situations, Twitter is the go-to news outlet. A couple of years ago now, we learned of the shooting at the Pulse nightclub in Orlando, first on Twitter. And it was reported by the people who were there as it happened. Here's the first tweet. OMG, shooting at Pulse. We hid in the bathroom and we can't find our friends. And then the owners of Pulse went straight to social media. Everyone get out of Pulse and keep running. And then the Orlando police also went to Twitter to keep people updated. Pulse shooting, the shooter inside the club is dead. Think about that for a moment. The Orlando police communicated the biggest news likely in its department's history first on Twitter. And of course, that's where our president lives. And that's where the previous president lived until he got kicked off. But that's where many of our legislative people live, right? Social media is arguably the most powerful tool we have for distributing and receiving information in the middle of a crisis. And there are guiding principles that apply to these interactions. Here's social media general guidelines. Number one, be transparent. Online audiences expect open communications. They will see through any attempt to hide or cover up the facts. Trying to be anything other than fully transparent will erode the trust you have built with your stakeholders. Be responsive. Listen, online communication is a two-way street. If you want to just give out news, put it on your website. But if you want to be social, engage in social media, right? When your stakeholders address you with concerns and questions through your social media account, they will expect timely responses. I'm sure you've encountered that. Be fast. Social media sites such as Twitter thrive on real-time communications. They've turned what used to be a 24-hour news cycle into a 24-second news cycle. Therefore, it's important to be as timely as possible with your communications. If you're not driving the conversation, somebody else is, and they may not be giving the proper information out. Couple your words with action. Your online constituents will only be motivated to support you if they see that your organization is following through on its promises. So if you offer to address a situation or solve a problem, make sure your village is prepared to act accordingly and do that. And finally, be professional, but be human. Listen, social media is, after all, about being social. That means using language that incorporates compassion, understanding, gratitude, respect, and even remorse, if appropriate. Corporate speak and legalese does not win friends and supporters online. Nobody wants to hear from your attorney when you're in the middle of a situation about what you can't say. They want to hear from you about what you're doing, right? They want real talk from real people. Here's one of my favorite examples of being professional and being human. A Red Cross social media specialist thought she was tweeting a friend. This tweet went out to the entire Red Cross Twitter feed in the world. Ryan found 2 more 4-bottle packs of Dogfish Head's Midas Touch beer. When we drink, we do it right. Hashtag getting slizzard. The tweet was up for about an hour when the Red Cross social media director was alerted to it. Immediately, they took the tweet down and apologized on Twitter. But she didn't stop there. The director, impressively and quickly on her feet, put up this tweet. We've deleted the rogue tweet, but rest assured the Red Cross is sober and we've confiscated the keys. It was a great tweet. It was a good response. This was a self-inflicted wound, right? So they could put a little humor in it to get out of this situation. The final result, Dogfish Head Beer staged a fundraiser for Red Cross. Red Cross was praised for its response, and traffic to the Red Cross site actually increased. They got more followers and supporters because of this situation. Granted, this was a self-inflicted wound, and many of these types of crises are. So responding quickly with a little self-deprecating humor just might win more friends on social media, and it could end a potential crisis really quickly. Here's what people really want from government on social media. They want engagement. If you maintain a presence online in an official capacity, your constituents expect you to be willing to converse with them online and hear their thoughts and concerns. When Cory Booker was the mayor of Newark, New Jersey, he became legendary for the way in which he engaged with constituents on social media. In doing so, he brought people closer to government and made them feel more connected to him as an elected official. They also want education. You're expected to educate your constituents on important matters they need to know about. That could be something as simple as trash pickup being delayed, or something as consequential as a new commercial development happening near their neighborhood. With that being said, there are certainly some best practices to use with social media. And I know there's a lot, I'm giving you lots of things. If you guys want this PowerPoint presentation, I'm happy to send it to the mayor who can disperse it. So just let me know, after this presentation. But here's some social media best practices. Monitor and be prepared to respond. Again, we're in a 24/7 news environment. If you are posting, you need to be monitoring. This gives you a good early warning system for problems that are cropping up in your constituents area, right? In your village or your township village. So it gives you an insight into what's going on in community members' minds, right? What are they thinking? Hiding from social media will not make online criticism go away. I know you think it will, but it won't. Not responding to someone that's criticizing, that's a risk. I always tell people, if it's just a criticism, if there's no if it's misinformation, which we'll go, this is the next one, don't let mistakes live on. You need to correct misinformation. But if it's just, you guys are terrible, I can't believe you made that decision, let it stand. People will come organically to your rescue. So don't let mistakes live on. Respond and correct misinformation in real time. Do not allow misstatements of fact or incorrect characterizations of your organization to go unchallenged. Correct the error in a straightforward, professional way, but make sure it's an error of fact and not just someone's opinion. And correct errors once, which brings me to my next point. Don't arm wrestle with trolls. Resist the urge to get caught up in exchanges with rude or obnoxious people on social media. Respond to correct errors, but don't feel compelled to continue the conversation should that person challenge you or your response. Because you'll never change that troll's mind. You're actually talking to everybody else watching that conversation. Pause before hitting delete. Now, I'm sure your attorney told you about this. You cannot delete posts. These are public records. Okay, so you can't delete. You might be able to hide posts in certain circumstances. You should check with your law director. So when I say delete, I'm talking about hiding with you guys. So pause before hiding posts. Resist the urge to hide a negative posting on your official social media site unless they are offensive, meaning they are racial, profane, personal attacks, threatening. If you remove a comment or hide a comment, you need to say why. This is councilperson K. I removed the previous comment because it was a personal attack on an employee. Please be kind to one another, right? Explain why, because I got to tell you, if it just disappears, that person has already screenshotted it and they're going to put it back up and say, oh, you can't say anything bad, right? You guys have all been through this. They've screenshot, they're going to start posting it everywhere, but say why. So your other constituents know why you removed it and they will approve of that. Trust me, if you're just forthright. Go offline to get back on track. This is really important. I did this when I was the communication director for the city of Akron. If someone was saying things, so the mayor's office never gets back to us. It's been weeks, or I have a complaint about garbage and nobody would respond and it's piling up in my front yard, et cetera, I would get on there and say, this is Stephanie York, Director of Communications for the City of Akron. I'm going to send you a private message with my contact information. Please contact me. I'd like to work this out with you. One of two things happened. They were either so shocked that somebody from that high up in the mayor's office on their cabinet responded, and so they didn't do anything, and they took the post down or whatever, or two, they would contact me. And most of the time, when you get somebody online who is that vicious, if you get somebody on the phone that was that vicious online, they are totally different when they talk to a person, right? They're not hiding behind their computer, pounding out these nasty thoughts. They're talking to a human being that has reached out to them to provide help. If nothing else, they want an ear to bend, to complain to. And I got to tell you, I would say 95% of the time, I was able to resolve the issue or at least explain what happened so that they could understand that they were not intentionally, skipped on the trash route or, intentionally hurt. I was able to fix it. And then they would go back online and they would say, hey, this worked out, we worked this out, or they would take the post down. Really important to go offline because sometimes you need to do that to rein things in. You know, I had people that were going to protest once, and we just called them in for a meeting while they were trying to get people to protest. They had, you know, online, they were riling things up, and we're like, we'd like the head of your organization to come and speak to the mayor and, you know, the council people, and let's sit down and talk about this. You still can protest. You have every right to do that, but can we talk about this first and figure out a resolution? It really helps. Know who's running the site. If serious, incorrect information appears on a news outlet's comment board or social media site, consider contacting that publication's online content manager. They're usually titled online editor, director of digital operations, or sometimes the director of community engagement. Request help in having the comment removed. They don't want false information on their site either. So you got to be able to prove that it's false, and then they'll give you help taking it down. And finally, remember your audience. You are not speaking to the troll or to the one complainer. Every time you post out there, you're speaking to all of your constituents. So whether you're angry at the person you're responding to, just remember that's not who you're talking to really. You're talking to the greater community. So social media presents a new challenge, and you probably got some of this from the law director. Record retention, right? And if you think that's a challenge for you, consider the Library of Congress. The library collected every single public tweet from 2006 to December 31st, 2017. As of 2013, the Library of Congress reported it was collecting 500 million tweets a day. Eventually, the librarians screamed "Uncle," and they started to preserve tweets on a selective basis. And that included tweets of President Trump and other lawmakers, for example, but not every single public tweet. So now they're probably just collecting tens of billions instead of hundreds of billions, right? So what about you? While I would definitely defer to your law director for definitive specific guidelines, here are some broader guidelines. Ohio state records law do include content from websites and social media. The Ohio Electronic Records Committee suggests that developing a social media management guideline should be the important first step for government agencies. That means you've got to take into consideration the content on your sites, when a public record is on them, and how you'll then meet public records law for retention, disposition, etc. If the information on your social media site is deemed to be a public record, the next question is it a primary or secondary copy, right? Is it duplicated elsewhere? Let's say a press release distributed on paper, then it should be considered a secondary copy. If the information is a primary record, the only place you put it was on social media, then you have to retain it with your agency's record retention and disposition policy. Retention of documents, including social media, is based on the content and not the platform. And then, of course, how do you preserve these records, right? And then how do you find what you've preserved when somebody asks for them? I mean, it just goes on and on. So there are archiving solutions. Sites like Facebook and Twitter offer archiving apps. They actually are the holder of the records, so you could probably request from them. But companies have popped up to help with archiving and searching preserved social media content. There is a cost there, obviously, and take care to make sure these companies have a tool that fits your needs. We don't have any relationship with any of these companies. These are just some: Preservica, Archive Social, and Reged. They're examples of what we could find that at least market a government-specific archiving service. And because public records may be involved, blocking users to your social media sites or deleting posts may be seen as violations of open records law and even the First Amendment, which we talked about at the outset today. So can a public body ever delete comments? Well, I did indicate yes. Based on best practices being used nationally, you are on safe ground deleting. I still wouldn't delete, I would hide instead of delete, but hiding comments from citizens if they are abusive, threatening, sexually explicit, obscene, discriminatory, or have a commercial advertising or links to third-party sites. Those are the kind of things nationwide that have been cited as things you can block or hide. I wouldn't say block, I would hide them. But even within that, we see the slippery slope. For example, is the post really discriminatory, and in whose opinion is it discriminatory, right? So you have to balance that. That's why we recommend conferring with the village's attorney or other attorney well-versed in case law before actually removing the post. We strongly advise all clients who have social media sites to set out terms of use for your site. So like on your Facebook page, in the About section on your Facebook page, tell people that the posts that are obscene or profane or threatening will be removed. And it's not a surprise when you do that. You always reserve the right to hide offensive comments. That disclaimer won't always hold up in court, but it's important nevertheless to have it there. Because if you do delete a comment, we can virtually guarantee that that commenter will then repost it on your site, right? Having these rules for social media pages allows you to cite the rules when you remove the comment. Here are more best practices for elected officials with social media accounts, primarily drawn from a very helpful document from the Association of Washington Cities. Okay, you must make a clear distinction between official village accounts, campaign accounts, and personal accounts. One way elected officials can clearly distinguish private social media accounts is by adding disclaimers in that About section on Facebook. On election sites, same thing, and on personal accounts, and not using the account, any of those other accounts for city business. City-sponsored accounts may not be used for campaign-related purposes. I know you know that, but it bears repeating. Understanding and use the privacy settings to manage the accounts. Have a plan in place to respond to or forward city-related comments that show up on your personal page because someone knows you're a council person, but they're also a friend. So they might ask you something. Say, thank you for your question. I'm going to send this over to the village for them to answer so that you're not answering it on your personal page. Because once you start using your personal page for answering political or village questions, you've now opened it up to being a public page. So anytime you get a village question, say, thank you for your question. I'm going to send that to the village or to my village page or to another, some official public page for it to be answered. So have a plan in place to respond to or forward city-related comments to the city, including how the record is retained. Establish a process to follow if you receive city-related question or comment on your personal account. Outline how the question or comment will be addressed. So I'm going to send it to the city. I'm going to have the director of the personnel director answer your question, right? And so you can follow up with Mr. So-and-so or Miss So-and-so. Okay. Best practices don't write posts on personal accounts that would fit the scope of your employment as a city council member, period. Once you do that, it's now a public site. Don't discuss your private accounts in public meetings or documents, right? So don't refer anybody to your private, like if you're in a council meeting, say, oh, I'm also on Facebook here. Once you put it in a public meeting, you're making that a possibility of being a public account. Don't link your private accounts from official city account. So don't send people to your personal account from a city account. Don't use city devices to maintain your private account. And when does social media chatter become a public meeting? Now that's interesting. According to the National Conference of State Legislators, if you have a quorum discussing or commenting on an issue, that becomes a public meeting. So if you have several of your council people piping in on social media, you have now made it a public meeting. If you are discussing any official business, policy, or public matter that is formulated, if you're formulating it, presenting it, discussing, or of course, voting on it, that is a public meeting. It's potentially a broad definition. Court guidance is evolving. I mean, this is not set in stone. This is a process. But the bottom line is to avoid inadvertent exchanges that could violate notice and public meeting requirements. Now I'm going to go back briefly to, I talked about this, but I didn't advance the slide. Sorry, but you'll get a copy of this, I promise. Okay, back to the damage control playbook. We're now on rule number 5. Okay, tell it to the people who matter most. So when you're dealing with conventional media, you're dealing with mass media. Mass media is good. You get to talk to a lot of people all at once. All kinds of people are watching that newscast or reading that website or reading that newspaper who don't know or care about you though, right? So when we come across a sudden situation that you want your constituents to know about, we are most worried about getting to the people who really care about you. And that's not through mass media. These people are your key stakeholders. They're your employees, your constituents, your vendors, other local officials. You get the idea. Those are your stakeholders. We want you to get your story to them first and fast. And there's lots of ways to do that without going through the media. Personal meetings. You can sit your employees down and talk to them, right? Personal meetings, phone calls, pick the phone up and call your school board president, call your other legislators in the area that need to know something, some uprising that's going on or whatever. Old-fashioned letters, if you need to get information out. Email is a great way to get to a lot of your stakeholders quickly. But one of the best ways, of course, is social media. People who care about you most, they care about your village most, will go to the village website. They will go to your Facebook page. They will follow your Twitter feed. And what we find is your most important audiences, if they hear from you first about what's going on, about your side of the story, they may not believe what they see on the blogs at 3, what they see in the news at 6 and 11 p.m., or what they read in the paper the next day. It doesn't take much to discredit the media these days without even taking a swing. You just have to tell your story to the people who matter to you most and tell it to them first. Social media is a powerful weapon for getting your side of the story out. It has become part of our lives. It's not going away. It's not going to become less important. We encourage you to make it part of your elected official life. It's a great way to open up government and give people what they want, which is a voice and access to you. But do so smartly with your eyes wide open. Now, I'm going to tell you briefly about, I'll take a few questions, but we have a newsletter called Crisis Management Today. You get it free it comes in email twice a month. If you send an email to Hennes, Hennes at crisiscommunications.com, type subscribe in the subject line and you'll get it. It has best practice link. We don't sell you anything. We just tell you about things that happened in the news and how they did it right, how they did it wrong, things they can change, how to work with attorneys. All sorts, when you're in a crisis, all sorts of ways to deal with crisis and dealing with your constituents. So that is the end of my presentation. And I gave you a ton of information. I really did. I had a hard time. I had to boil down 2 hours of social media I was given 30 minutes and I went a little bit over. So I'm sorry. I'm going to stop sharing so I can see all your lovely faces better. Okay, question. Shout it out.
Mayor,
Yeah.
I have a question. Okay. I love how you pointed out the positives and the negatives of social media. We do have a person on council that reminds us, and I do listen when we tweet, I think I said that right, or on Facebook, and we are under our own personal name, but we're tweeting something about the village. I had never thought about it that way.
It makes it hard.
You think your personal page, I can say what I want to say, but as an elected official, we have responsibilities.
Correct. And you also can't block people if it's a public page. You can't block people and you cannot. That's what that one person said at the beginning. She said, I thought it was my personal page. He said, well, you were talking about policy on it. So you can't block people and you can't hide their comments, even though you call it a personal page. So it's really important to make those distinctions. Yes, Tanya.
This was a really good class today. I learned a lot, especially in the world of social media and communications, getting communications out. So I question popped in my head when you
Sure.
made the comment that a social media post can be considered a public meeting when you have engagement from multiple people, because I think a lot of us are Facebook friends with
Sure.
each other. And so my question is, sometimes I get added to emails using my village email account, and I've seen other elected officials from our community added to those emails as well. And some of those emails I feel uncomfortable with
Yeah.
because of the nature of the email. And so
Sure.
I've beginning to use a practice of, please remove me, my comment in the email. Please remove me from this email communication.
Yeah.
Trying to protect myself.
Sure.
I can only
And the
protect
village.
myself. And the village, but
Right.
myself specifically in that instance. So what can we do, or do you have any recommendations beyond that we can protect ourselves from having meetings or
Right.
conversations about whatever it might be
Right.
that's we've been pulled into from various
Sure. So
forevers?
are all your council people on this meeting right now? Okay.
Yes.
Okay, so this is a really good example. You guys are all on. You now know that if you have a quorum and you're discussing something, if you're online and you're all discussing something, that is could be considered a public meeting where it needs notice and you need to invite the public and all that. So you need to be very careful about that. I don't know about emails. That's not my forte. I don't remember. I would imagine though that emails where you're all discussing policy is subject to the public, because you're supposed to do that out in the open. That's the sunshine laws, right? You're supposed to do that with notice. So you are all on the line. You now have notice. You should know that if you are participating in this, you should say, hey, there seems to be too many people in this conversation. We need to either go into a public conversation on this, or we need to break up into smaller groups. Right?
Yeah, Stephanie, even for this training, we posted it and we also
Yes.
put it on our link for the public to watch.
I saw that. That was great because I mean,
Yeah.
you have to. You're all together. You have a quorum. It's the sunshine law. Mandates it. So I don't know that it's necessarily the forum that dictates whether it's a public meeting. It's how many people are there and what you're discussing. So
Mayor, I have a question.
yeah.
Yes, ma'am.
So there was a post in a public group called I Have Roots in Lincoln Heights. And
Sure.
the complaint was that there was a refrigerator on the sidewalk and the lady was showing where she was taping it up. And someone responded, Laverne Mitchell, like, if
Sure.
I was seeing it, I'm supposed to do something. So I did respond and said, I will definitely tell the manager about this.
Perfect.
So I'm good with that.
Yes, because
It's okay
you
to
are
do?
referring a city matter to the right city person to handle it.
Okay.
Which is what I would say to do. Listen, it's pretty, you should, this is Laverne, I am a city council person. I'm happy to forward your complaint on to the right person to take care of it. That's part of your job, right? But if that was your personal page, I would tell you to do the same thing. Thank you for bringing that to my attention. This is my personal page. I'll send this to the proper city person to take care of it.
Okay.
So that you're letting them know this is a personal page, but I'm going to send that to the right person at the city so they can, handle it.
Now, I started to respond like, well, hopefully it doesn't have Freon still connected. Could I have done that, even though I'm still going to send it on?
Well, I mean, as a concerned citizen, for sure,
Okay.
because you're not, in that case, you're not responding as a council person. You're
Okay.
like, right? I mean, any concerned citizen, and you should be like, and also I'm glad you're taping it up because that's required, that's a safety
Exactly.
hazard for kids. As a citizen, I'm glad you're doing that the proper way, and I also hope this, but you should always distinguish when you can, whether you're talking as a citizen or whether you're talking as in your capacity as a council person. And that's really easy to do. You could say, as your friend, thanks for bringing that to my attention, but this is village matter. I'm going to send this over to the village to handle.
Thank you.
You're welcome.
Yes, Vice Mayor.
Oh, sorry.
I'd like to see a bigger social media presence with the village of Lincoln Heights so that the phone calls will stop.
Oh,
For
yeah.
example, the other day, we have a group me at work. I work at the elementary school, and it informed staff not to take Adams coming into work because there was a police standoff. And that was not the case.
So you got a
So,
million
you know,
calls
those
about the
teachers
police.
made phone calls or they made posts saying false information. And I get to work and they all questioning me, but Stinson, what's going on? I get questioned at work all the time about stuff and I don't know. And they look at me like, well, why don't you know? I'm thinking, well, that's the police. The police can't
Right.
tell me everything.
Right.
Or where did you get that information about the standoff? That wasn't a standoff.
Right.
But if we had a social media presence, it would have already been said what that was.
Absolutely.
Or
And a
what
lot of
was
times,
going on. Or if
yes.
we did get a call, it's, but a lot of things people don't understand with the police. We don't know.
Do the police have their own social media site or anything in your village? Because a lot of villages do. Well, so there's a village page. You can always post that information on the village page saying there's been questions about a police standoff on that. There's no police standoff there. Traffic is normal in that area, or there was a brief accident. It's been cleared, but that's a good place and to tweet it because people will be coming and asking questions of everyone. But if they know that you're posting updates, they'll go to the village website and they'll go to the village, person that does social media if there is somebody. But you're right, a greater social media presence prevents all those other people coming to you individually, right? So there is a big upside to having a good social media presence.
Yes, Ms. Boudreaux.
Thank you, Ms. York. This has been some invaluable information, and thank you, Madam Mayor.
Welcome.
But I just want to let council know that I have been doing research on how we should improve our social media. So this was very helpful in terms of how we create the right foundation for that. And people know the ground rules, so everybody's in the room now. So they know the ground rules. And so I will be presenting that to council, how we will move forward with our social media. So if you are not a social media person like myself, we may want to do some more extensive training in that area as well.
Well, just so you know, my colleague and we have a 2-hour version of this that goes into more nitty-gritty details. I was asked to condense this, which is fine because this is a retreat and, you don't want 2 hours on this today. But if you're developing this program, that might be helpful down the road for you. I commend you, just like the law director did, for doing this on a Saturday. That's really great that you're getting it together and that you're talking about these issues, because again, social media is not going to become less relevant as time goes on. It's only going to become more relevant. So you really need to embrace it and use it for the good that it can be. There are negatives, but there are ways to combat that and to deal with it.
Yeah.
So yeah, if you have questions down the road, feel free to email me. I'm sure the mayor can give you my contact information. I'm happy to answer them. And Mayor, would you like me to send my PowerPoint presentation to you to disperse?
Yes, you can.
Okay.
All right. If there's no more further questions, Mr. Desai, was you about to say something?
Nope.
Okay. I think
Bye. Thank you. Sorry I went long, but this is important stuff.
Great.
So
now you asked for wiggle room. So
I did. I took a lot of it though.
Yeah.
I'm sorry.
Yeah. And the questions and answers was, I'm glad that council is engaging.
Yeah, me too.
We went on, and I expected a little wiggle room. That's why we had to add another hour on for, to allow us running into some of the time slots a little past that. But I did want to, I know when we started the meeting and everything, I had not left out, but I wanted to formally introduce Ms. Powdrill, and I know with the residents watching, I did want to let them know that she is our newest village manager. And we just wanted to have her say something, and I just wanted to just put her in a middle time slot. So in case our residents are not going to be with us when we take our little break and may not come back on, I wanted to allow her. I just didn't want to just say her name. So I just wanted to introduce her, not to just ones that are watching, but the ones that will watch later on, our village manager, Ms. Joyce Powdrill.
Thank you again, Madam Mayor. I just want to just briefly say thank you for giving me the opportunity to help lead the village. The council has, I feel like, embraced me. They've listened to some of my ideas. I'm excited about the future of the village of Lincoln Heights, and I'm looking forward to having the opportunity to move the village forward in a long-term relationship with the village. So thank you, Mayor, for giving me that opportunity to say that.
Okay. So what we're going to do, I know Mr. Desai had Emily on for the first half. So thank you, Mr. Desai, for letting Emily to do the first half. We're going to take a break if that's okay with everybody. I'm glad that you all picked up your box lunches. Mr. Desai declined, but that's okay. Because he has some other things going on with him. So I'm very excited. Very good training. And so if you all want to take a 15-minute break, we're going to resume on time. It can be 10 minutes. What is your pleasure? Y'all want to do a 10-minute?
I'm good on 10 minutes.
10 minutes good for me too.
Really don't want to take any, but I'll take 10.
All right, we'll take a 10-minute break and we'll come right back.
Okay.
All right. Everybody ready?
Mayor, I may have to leave early.
Okay. All right, we're gonna go ahead and get started. Gigi, be ready? Are we ready? All right.
Yes, you are.
Okay, let's resume the parliamentary retreat. Mr. Sy, the floor is yours.
Thank you, Mayor. Good afternoon, everybody. So I understand,
Hey.
I talked to Emily during the break, just see how everything went. It sounded like it's been a stellar training session so far. I understand the first speaker went through the sunshine laws, which of course covers the Open Meetings Act and the Public Records Act. And then I believe the last presenter went through social media. Sounds like that was a really fascinating topic to go through. So it's been good so far. And you all got my outline, and believe it or not, that's an outline that we use when I do my 3-hour training, and it's hard to get through that outline in 3 hours. So what I thought we would focus on is some motion practice. So I'm going to basically go to the motion section of my outline, which has to do with procedural motions prior to debate and procedural motions during debate. And this is on page 3 of my outline under item J. So in the Code of Ordinances, we actually have codified the rules of council. So these are codified in chapter 38. And we have a whole bunch of rules for council, but within those rules, you also have the rules regarding motions. And I want to start with the first one, which is called a motion to defer consideration. And basically, when we're looking at this motion, what typically happens is we will have a motion made, and then we will have a second of a motion. And of course, that second brings the motion before council. Then the mayor will usually ask, any discussion, any debate, interchangeable terms. And before that discussion or debate starts, a member may move for deferral of consideration of an action on any subject prior to debate on the subject. So just to give you kind of an extreme example, let's say somebody made a motion that moving forward every day, we've all got to wear pink socks. And it, for some reason, got a second so that the motion is actually before council. So you have a motion that likely is not going to go anywhere. And, at least one member might think that it's not even worth debating. Why are we even discussing this? So there's a motion that everybody wears pink socks going forward, and it's got a second, so it's before council. A member can make a motion to defer consideration before discussion actually starts. That motion then takes precedent over the motion to wear pink socks, and that will have a vote. So like any motion, it's got to have a second. So motion to defer consideration, if it gets a second, then that motion is voted on. And if it's passed by a majority, 4-3, then the motion to wear pink socks never gets discussed. So again, this is a motion, it's called a motion to defer, and it's a motion that is made prior to any discussion being started. Once discussion starts, so again, going back to this example, motion that everyone wear pink socks, it receives a second discussion. If somebody starts discussing the motion, you cannot use the motion to defer. The motion to defer has to be made prior to debate starting. So it's not a motion that we're going to use very often. but it is a motion that allows the business of council to continue to move forward if there's something that comes up that clearly is not going to be entertained by council, or something that council just doesn't want to discuss at this time. And there's, a belief among a council member that if they make the motion to defer, it will be granted. Any questions about the motion to defer?
Yes.
Okay. Yes, ma'am.
So once the motion to wear the pink socks is made, before the second is when you make the motion to defer.
No, you'd make it after the second.
So once somebody seconds, then the next thing would be to make a motion to defer.
Correct.
Okay. So when you say discussion, that means like when she say, are there any questions?
Correct.
Or you just start talking about it in any
Correct.
type of form. Great. Okay, good. I like that.
Yeah. So yeah, once again, motion to wear pink socks by council member 1, council member 2, second. Mayor, any discussion? Council member 3, motion to defer. That's all you have to do. And once that motion is made, then that motion has to be voted on if it gets a second, okay?
And it doesn't have to be like something silly like that, but it could be something just that you think maybe should, I'm trying to get of another example other than, because all I can think of is Dr. Seuss in my head. When you said pink socks, what something different that would be defer? Would you defer it to a committee?
No, it's just that's a motion to refer.
Refer to a committee. Okay, defer means just can we talk about that another time?
Yeah, and it basically just stops any discussion of that particular item.
Okay.
Yeah.
Deepak, I have a question.
Yes, ma'am.
So when you say it stops discussion of that particular item for that particular moment or the rest of the evening, can that subject matter be brought up again?
It's done for the evening. It can be brought up at another council meeting, but it's done for the evening.
Thank you.
You're welcome.
So to decide, in essence, that's a motion that could kill a vote.
It basically, it's very similar to a motion that we're going to talk about called motion for the previous question. But the difference is you don't even entertain the topic. Okay. Whereas with the motion for the previous question, the topic is entertained.
Right.
And you're basically just cutting off discussion, questions, debate, and calling it for vote.
Got it.
Yeah.
Thank you.
You're welcome. Any other questions about the motion to defer? Okay, well, let's move on then. And again, that's what we call, if you're looking at my agenda, it's called a procedural motion prior to debate. Debate being synonymous with discussion, questions. So that is the motion prior to debate. We then have a whole slew of motions that can occur during debate. Now, remember, the basic premise is that once a motion is made and it is seconded, that motion is the priority for council. So that motion needs to be disposed of before you can do any other business, before you can take any other action, except for the motions we're going to talk about now, which are known as procedural motions during debate. So again, you've got a motion on the floor. It's been seconded. Discussion or debate has started. Now the question is, what motions can you raise while that motion is being debated or discussed? The one that we were just talking about, so I will go ahead and start with that, is called the motion for the previous question. And I'm just going to read the rule. It says, approval of a motion for the previous question to close debate shall be by at least 5 votes of the members. Adoption of a motion for the previous question shall close debate, and the village council shall immediately proceed to a vote on the pending question. So let's break that down a little bit. Again, we're in the middle of a motion having been made, it's received a second, the mayor is called for any questions, again, questions being synonymous with debate, discussion. And now we are talking about motions that can be made while that motion is being debated. So this one, called a motion for the previous question, is a way to end discussion. So as you probably have experienced at least one council meeting, there can be times when discussion goes on and on and on about a motion on the floor. And sometimes that could be just one or two members who really are continuing to churn through that particular discussion, whereas there might be a sense that the other 5 members are ready to vote on it. You know, we've talked about it enough, so to speak. So if you are ever in a position where you feel like that's what's going on, you can call the previous question. And so you would make a motion for the previous question. And basically what that does is it causes a vote to be taken on that motion. And if there are 5 votes in favor, and that's an important thing because there aren't too many motions that require a supermajority, but this is one of them. And it makes sense, right? Because you're ending debate on a topic. So the idea behind Robert's Rules of Order is that there should be an overwhelming majority that wants to move forward with the vote. It shouldn't just be a simple majority. So once again, you motion for the previous question. The mayor, if it gets a second, the mayor will then ask the clerk to do a roll call. If 5 members vote in favor of the motion for the previous question, that means all debate, all discussion, all questions stop. And then the mayor will say, clerk, please do the roll call vote on the motion that's actually before council that debate has stopped on. So since we started with pink socks, we may as well continue with that. So there's a motion for everybody to wear pink socks. It's received a second. The mayor's called for questions. There have been questions, discussions going on for a few minutes. A council member says motion for the previous question. It gets a second. The mayor stops, says I need a roll call vote on the motion for the previous question. It receives 5 votes. That means it passes. That means all debate stops on the motion for pink socks. And the mayor will then say, I need a roll call vote on the motion for everyone to wear pink socks. So that is a valuable tool if there is just sort of endless debate going on about a topic and a majority, really a supermajority of council would like to move forward with just having the vote on the actual motion itself. Any questions about that one?
Yeah, Mr. Desai, would they use that same way during like their committee meetings as well?
Yes, these motions would all be handled the same way in any committee meeting, any even an ad hoc committee. Anytime you're following the Robert's Rules of Order, you're doing parliamentary procedure, these motions would apply equally.
Okay. Ms.
I have a
Faber,
question.
Mr. Daniels, I haven't heard anything from you guys. Anything y'all want to ask Mr. Desai on this topic? To benefit your committees when you have them?
I don't have any questions at this time, Mayor.
Okay, Mr. Daniels?
I don't have any questions at this time.
Okay. Ms. Mitchell?
Yes. So Mr. Desai, once we get back to, thank you, Mayor. Once we get back to the motion for the pink socks, is there another motion that can stop that particular motion at that time?
Yeah, so there are, let's see, 1, 2, 3, 4, 5, 6. Yeah, there's 6 motions that can be used when there is discussion going on about the motion for pink socks. And so there are, the next one that can be used is you could make a motion to postpone indefinitely. You could make a motion to refer. You could make a motion to postpone to a time certain. So there are several motions that you can use, to do other
Delay that
things.
particular motion.
Yeah, do other things. So let's talk about the motion to refer, because that's one that does come up from time to time.
So, Mr. Desai, before we go there, I just had
Yep.
one question based on the last motion that you were referring to. So you have a motion, Pink Sox motion, and somewhere motion for the previous question. What happens, or what is the recourse that a committee chair can take if members of council continues to proceed with discussion?
Has the motion for the previous question been seconded and voted on?
Correct.
And it has passed by 5?
Correct.
Okay. So then if somebody were to continue to discuss it, they would be out of order. And what the chair would do is say, pardon me, council member so-and-so, but you're out of order. We have a motion for previous question that's passed. It's been, we must now proceed to vote on the motion for Pink Sox.
Thank you, sir.
Yeah, my pleasure. So the motion to refer, I'm just going to read it. Again, these are in the rules of council in chapter 38. Motion to refer, approval of a motion to refer may commit or recommit any pending question to a specific standing committee, or may refer the matter to a special committee, the village manager, a board or commission, or a department director for investigation, report, or action. The response to such referral shall be made to the village council or as the village council otherwise directs. So sticking with our example, we have a motion for everyone to wear pink socks. It's received a second. When the mayor called for questions, there was not a motion to defer, so it is now being discussed. At any point, somebody could make a motion to refer it. For example, someone can make a motion to refer to the law director to determine whether it is permissible to order people to wear pink socks. Somebody could make a motion to refer it to the safety committee to determine whether or not pink socks would make people more visible when they're walking down the street. This is a motion that we do use because we do have things come up. The most recent one that I can remember is we had a resolution to adopt the International Property Maintenance Code, and we did a first reading, I believe, on it, but then it was referred to the law committee, if I'm remembering correctly, for review. And so that's a very good example of where you would use it, because everyone kind of understood this is a brand new property maintenance code. It's very comprehensive. There are going to be some things that we want to tweak on it. And so the idea was to get it on the radar, but nobody, I think, really had any intention that night of passing it until it, had been reviewed. So motion to refer is one that we use often, so to speak, at least compared to the other motions in here. And it's one that is a good tool whenever council is entertaining a topic, but wants to have somebody look at it and provide a more comprehensive overview and report before council takes action. Any questions on the motion to refer?
Good. I think I'm good. Okay.
Okay, so we've covered the motion for the previous question. And again, these are motions during debate. We've covered the motion for the previous question. We've covered the motion to refer. Let's do one that we also use from time to time. This is called the motion to amend or fill blank. A motion to amend may only be amended once. An amendment once rejected may not be moved again substantially in the same form. A motion to fill a blank shall be made prior to voting on a resolution or ordinance. This one is interesting because it dovetails into one of the provisions in the charter, which states that after the second reading, and the charter reads kind of funny. I think it uses the word engrossed, but basically what it's saying is that after the second reading of a resolution, you may not amend it. In other words, if we are going to amend a resolution, we need to amend it after the first reading. And I think everyone kind of remembers that we'll often in Council of the Whole talk about, a fund number needs to be put in, a dollar amount needs to be put in, something's been left blank in the resolution. And we'll talk about the fact that when we get to regular council meeting, after the first reading, somebody needs to make a motion to amend. And it could be to, clear up a typo, but that motion to amend, although the way it reads in the rules of council sounds like you can do it anytime prior to the vote, because of the provisions of the charter, which of course trump everything, because the charter is our constitution, if you will, because of the rules of the charter say that you cannot amend a resolution after the second reading, you want to read those two provisions together. So a motion to amend can be made to fill in a blank, to correct a typo, to delete a provision if somebody so desired, but it has to be done after the first reading and before the second reading. Any questions about that motion? Okay, that's one I think. Yeah, well, that's one we use a lot. So I don't think anyone really is unfamiliar with that. All right, now let's get into some of the ones that are a little more esoteric. The first one I'm going to do is called motion to lay question on the table. I just love that one. Motion to lay question on table. This one says approval of a motion to lay the question on the table temporarily lays the question aside so that it may be taken up when it is in order or when no other question is before the council. No amendments or debate of the subject may be considered. If the motion prevails, all amendments and documents accompanying the question shall adhere to the item. The consideration of the question may be resumed only upon motion of a member voting with the prevailing side and with the consent of a majority of the village council. That's a lot. That's a lot right there. So let's kind of start with the big picture. The basic idea here with this motion to lay the question on the table is that something has come up. A motion to defer was not made prior to debate because it seemed like something that council may want to go ahead and move forward on. But it becomes clear during the discussion, during the debate, that there's lots of questions that need to be answered. There doesn't seem to be any consistent theme from council in terms of, do we want to refer it? Do we want to move forward with it? What do we want to do here? So this would be the situation where you would say, I make a motion that we lay the question on the table. And what you're basically saying is, it doesn't sound like council really knows what it wants to do with this thing right now. So let's just put it aside for the time being, and we'll come back to it another day. So I'm going to go through the definition again because I want to break it down, but that's kind of the overview of it. So approval of a motion to lay the question on the table temporarily lays the question aside so that it may be taken up when it is in order or when no other question is before the village council. So literally read, what that would say is that, let's say that's agenda item 4, but you have 5 or 6 other agenda items. upon a successful motion to lay the question on the table, at the end of the agenda, once all other business is gone through, then the question should be taken up again. So in other words, the motion to lay the question on the table doesn't do, for example, what a motion to defer, which you can make prior to debate, does, which is to just completely move it off until somebody actively brings it back up. The motion to lay the question on the table basically pushes the item down to the bottom of the order of business, so that when council goes through all of the other business, it then comes back up for discussion, which might require another motion if it still is sort of in limbo in terms of where people are at with it. The other piece of this rule, which says, if the motion prevails, all amendments and documents accompanying the question shall adhere to the item. The consideration of the question, and this is the key for it to come back up at the end of council's business, the consideration of the question may be resumed only upon motion of a member voting with the prevailing side and with the consent of a majority of council. So again, that motion has been made, it's prevailed, it passed. It pushes the item all the way to the bottom of the agenda, but that doesn't mean that it automatically comes back. What would happen is when we got to the end of the agenda, the mayor would say, we do have, I forget what item number I said it was, let's say it was 5. We do have item 5 that is still out there, a motion to lay the question on the table passed. Is there anybody who voted in favor of that motion that would like to make a motion to bring it back? So if there is somebody, they would basically make a motion to resume consideration of that question. Somebody who did not vote in favor of the motion to lay the question on the table cannot make that motion. It has to be someone who voted in favor. And then a majority of council would have to vote in favor of reconsidering or continuing to consider the question. So I'm going to stop there because that motion is probably one of the most complicated motions in parliamentary practice. So any questions about that or would,
Yes.
yes, ma'am.
Mayor did and Ms. Key.
Yeah, what I was wondering is, would something like that be able to be tabled instead of amending the agenda? For example, if we had a speaker that was going to come and speak on a resolution or something, could we table something that was on the agenda just so that we could move that person up so that they could speak in case for time reasons? Do you
Absolutely.
understand what I'm saying? Instead
Yep.
of amending the whole agenda, just table that. But can you go down and table something that might be in the middle? Do you understand what I'm saying? Do we have to be at that subject to table it, or can we table it instead of saying amend the agenda? Can we table item number such and such on the agenda?
No, you have to actually be at that item, and it has to be under debate. Yeah. So if we're going to do it ahead of time, and I think that's an excellent question, Vice Mayor, because often in the council of the whole, we decide that we're going to amend the agenda because we want to switch things around or for whatever reason. That's still the preferred way to do it because you know ahead of time, so go ahead and do it. You know, for example, hey, we know the speaker that's item 4 is going to be running late. So what we're going to do is we're going to push resolution 1 to the bottom of the agenda. Do I have a motion to amend? You know, that's still the easiest way to do it because this procedural motion doesn't guarantee that it comes back up, right? It pushes it to the bottom, but then somebody who voted in favor of laying the question on the table has to make a motion to reconsider it. And then you still need to get a majority to say yes. And, you know, I understand we have some Pittsburgh Steelers fans and they may want to go watch the Monday Night Football game and not want to consider it. So, by the way, congratulations. I heard Big Ben's coming back. What's
right.
that?
Yeah.
What? I didn't hear what she
I'm
said.
not a band fan. I'm a Steeler fan.
You're a Steeler fan. Okay, I got you. Okay, so I'm sorry, Ms. Key, did you have a question about that as well?
Yes, sir, Mr. Desai, thank you. So the laying the question on the table, can we also use that? I know that I see to postpone indefinitely, so I'm not talking about that, but we can use that motion to lay something on the table until a certain time. Can that time be outside of that meeting? For instance, can we lay it on the table until the next meeting, or can we give it a date?
Well, so here, and that's a very good question, because you have 3 motions that are very similar to each other, right? You've got the motion to lay the question on the table. You've got the motion to postpone to a time certain or
Okay.
make special order. And then you got a motion to postpone indefinitely.
Okay, I didn't see that C. I hadn't highlighted it yet, but
Yeah.
that might be my question. Okay.
Yeah, but it's an excellent question, because these motions very much are complementary to each other, those particular 3. My interpretation, and the way I've always handled the motion to lay the question on the table, is that it doesn't give you the ability to say, I motion to lay question on the table until the next council meeting. My interpretation has always been, and the way I've practiced, is that no, that's not what that motion is for. A motion to lay the question on the table simply puts it to the bottom of the agenda of that particular council meeting, and then requires a motion to consider to be passed before it can be brought back up. Otherwise, it just dies on the vine, so to speak.
So and at that point, if anyone wanted to bring it back to the agenda at a different time, technically, could they do so? And does it have to be someone who voted in the affirmative to lay it on the table initially?
So at a separate meeting, it could come back on the agenda.
Okay.
Yeah.
Okay.
So yeah. So let's see. Yeah. So let me do this. Let me jump into, because I think that's a really nice segue into the motion to postpone to a time certain. And then we can talk a little bit more about motion to lay question on the table in terms of how those 2 interplay. And then after this one, I'll go to the motion to postpone indefinitely. So item C that Ms. Key was referring to, motion to postpone to a time certain, says approval of a motion to postpone to a time certain defers consideration of a question to another day or to a certain hour when, after pending business is disposed of, it will have the right of consideration over all questions except a specific order or reconsideration. It may be amended as a time by a vote of a majority of the village council. Approval of a motion to make an item, well, that's a different one. It may be adopted or may be amended as to time by a majority council. That's a special order one. So the last 2 sentences of C are about the special order. I don't know why the rules are put together like this, but it basically in C combines 2 different motions. But sticking with the motion to postpone time, once again, approval of a motion to postpone to a time certain defers consideration of a question to another day or to a certain hour when, after pending business is disposed of, it will have the right of consideration over all questions except a specific order or reconsideration. So going back to what Ms. Key was saying, if the idea was, I don't really want to lay the question on the table for it to possibly come back up at this council meeting, and I don't really want to ignore it. I don't really want it to be ignored. I want something to happen with this. You could make a motion to postpone to a time certain, meaning, let's say we had a resolution authorizing the amendment of or adopting the amended regulations for the stormwater district, okay? And council gets this and says, well, we'd really like to have somebody from the stormwater district come in at our next meeting and talk to us about what these amendments really mean. the motion to postpone to a time certain could be made at that point. In other words, motion to postpone resolution 2021-R-1, amending the adopted regulations of storm district to the next meeting so that the representative of the storm district can come and speak to us. That would be where you would use it, or an example of where you would use it, because it's not that you don't want to talk about it. It's not that you don't want to consider it, but there's a particular reason, such as we want somebody to come talk to us about this and explain it to us before we really take it up. So going back to the motion to lay a question on the table, that one really just pushes the item to the bottom of the agenda and sort of kills it unless somebody passes a motion to consider it at the end of the agenda. The motion to postpone to a certain time doesn't kill the item. It just says, hey, for whatever reason, such as in the example I just gave, we want to take this up at a later time. And we're going to go ahead and specifically state what that time is and when we're going to do that. So that one's like I said, a nice complement to the motion to lay the question on the table. Are there any questions about that? Nope. Okay, well then let's do the next one, which also is very similar to the motion to lay the question on the table and the motion to postpone to a time certain. And this one's called the motion to postpone indefinitely. And the rule reads, approval of a motion to postpone indefinitely rejects the question without a direct vote. If it is carried, the principal question shall be declared lost. An affirmative vote may be reconsidered. A negative vote may not. If the motion to postpone indefinitely carries and is not reconsidered, the question cannot be brought up again during that village council meeting. So this is very similar to the pre-debate motion called the motion to defer, right? So going back to the motion to defer, motion for pink socks, second, any questions? Motion to defer, Mayor. That motion basically kills the question, right? Prior to there being debate. Once debate starts, you can't use the motion for deferral, okay? But the complement to that, the motion that can be made during debate, is the motion to postpone indefinitely. So let's go through that one more time. It says approval of a motion to postpone indefinitely rejects the question without a direct vote. So just like the motion to defer, which occurs prior to debate and rejects the question without a vote, this one during debate, if it's passed, rejects the question without a vote. Now, the nuance is that unlike the motion to defer, it can be reconsidered.
Oh, okay.
So if the motion to postpone indefinitely passes, theoretically, someone could say either then or at a later time during that meeting, I move for reconsideration of the motion to postpone indefinitely. And if that motion carries, then it can be brought up during that council meeting. So that's the nuance with the motion to postpone indefinitely. Once the motion to defer, which again is the motion before debate, once that motion passes, it's passed and it's over. Whereas the motion to postpone indefinitely, which is the motion made during debate, even though that passes, theoretically, it can be reconsidered and the question can come back before council during that meeting. But if the motion to reconsider is not passed, then the question cannot be brought back up during that meeting, although it may be brought up in a subsequent meeting.
So, Mr. Desai, you're saying that if once that happens, it doesn't happen in that particular meeting, but it can come up at another meeting no matter when. 3
Correct.
months later. Okay,
Or even the very next council meeting.
okay.
Yes,
Oh, okay.
yes.
Mr. Desai,
Yes, ma'am.
can you tell me what edition of the Roberts Rules of Order you have? Because
I
I'm
got-
trying to follow along with you, and I have the new one that was ordered for us, and it
Mhm.
didn't read exact, and I'm trying to interpret the two.
Yeah, well, remember, we are going to follow the rules of council. So whenever there's anything specific, we're going to follow the rules of council because these are the rules that council has adopted for itself.
Right.
So understand that under in the legislative process in Ohio, you defer to Robert's Rules of Order if you don't have something specific in your own rules. But we are not required to follow Robert's Rules of Order. We can make our own rules. And so when council has a specific rule on a matter, we're going to follow it. Now, council can amend its rules. So if council likes the Robert's Rule better, especially the new version, it can amend its rules to match that. But as of right now, we're going to go with what is actually codified and adopted by council over the Robert's Rules.
I was gonna ask you about rules of council. So it just depends on when council wants to update or add. Have they ever done that? Because we've looked at things and it's just, a lot of it is vague. So that's why I was wondering, because there are some things that if we want to add to. Have
Yeah.
they done that since you've been the solicitor?
Yeah, when I first came on, I remember us amending these rules from time to time. And so, yeah, it's certainly council can amend their rules at any time. As a matter of fact, I'm looking at one, it looks like in 2009, we amended the presentation by members and the by leaves. And I remember that, and I mean, it's obviously 12 years ago, so my memory may be a little faulty, but if I recall, one of the problems we were having was that a lot of council members at the end of the agenda were using the by leave tool to raise brand new topics that were of substantive nature before council without there really being any information provided beforehand, without there being, any ability to vet it. And so, this was put in to to try and deal with that situation. And I believe it was item C, the clerk of council shall include a copy of the written request in the packet of information distributed to council members in advance of the council meeting. Any written request that is not timely submitted to the clerk's office shall be held until the next meeting. So it was just a way to try to stop that by leave tool being used at the end of a council meeting to well, hey, I want to, make a motion or by leave, I want to do this. And it was something of a substantive nature that really no one had any information on. So yes, we can amend rules of council if council so desires.
Okay.
Mr.
does that-
Desai.
Oh,
I'm
go ahead,
sorry.
Steve.
Okay. You sure, Mayor?
Yeah, go
Okay.
ahead.
So I want to make sure that I'm understanding correctly, or I'm going to make sure that I'm reiterating what you just said. In our rules, under motion, where it says village council, that's interchangeable with committee, right?
It is.
These motions can be used and should be used in committee form as well if the need arises.
Right, but the committees can adopt their own rules, right? So if they want to adopt their own rules, they can do that. They don't have to stick with these rules unless council wanted to make that a rule. So yeah, the hierarchy is this. These rules, these motions that we've talked about in the rules of council, it basically come from Robert's Rules of Order. But Robert's Rules of Order have evolved, if you will, since these were adopted. And I believe these were adopted in 1995. Take a look here. Yeah, these were adopted in 1995. So the committees are going to follow, again, defer to the Robert's Rules of Order and follow those rules. unless they want to adopt their own rules, or council wants to say, here are the rules for the committees.
So, Mr. Desai, do we have any,
Excuse me.
I don't know how to call it. Have we had committees to adopt their own rules as it pertains to making motions?
Not that I'm aware of.
So are there any rules that you're aware of that committee have adopted that are outside of our regular standard council rules?
No, not that I'm aware of.
Okay.
Not saying they haven't, but I'm just not aware of them, because I don't really get involved with the standing committees all that often. So, but of course, if they did adopt rules, those would be something that should be in the clerk's office. They should provide that to the clerk, and it should be something that is readily available.
And they would need to vote on that, because what if they voted on something that the body did not agree with? How would that work out?
Oh yeah, the rules would have to be passed by a majority of the committee. Absolutely.
So
But
then would those rules come out of committee for council vote?
No, I mean, the committees themselves can adopt their own rules of how they're going to function.
Okay.
Now, council can say, here are the rules for the committees. But if council doesn't legislate that, the committees are free to adopt their own rules.
Maybe that's what they did before, following along with what the charter says, because if that's the case, they could just make up something as they go along.
Well,
Can I
they
just
should
say-
be they should be defaulting to Robert's Rules of Order if they don't have any written rules.
Yeah, that's what I'm getting at. Ms.
Yeah.
Mitchell, did you say something?
Yeah, I want to say, for all of my experience, there has never been any committee that had adopted any separate rules. We just used the same rules that council always had. But the committees that I've been on over 20-something years, we've not done that.
Yeah, I mean, I'd find it hard I couldn't really understand why they would really need to adopt their own rules, because the rules that are in place would suffice for purposes of what they're doing. So from a practical standpoint, that makes sense to me that they would never have adopted their own rules and just followed what's there.
Yeah.
Okay. All righty. So those are just, some discussion points on motions. And, I like the fact that we don't get too overly caught up in motion practice. If you ever watch what goes on at the national level, especially in the Senate, where they seem to be very good at these type of gamesmanship with these type of things. It's nice to keep it simple, because really there's not much more we would need beyond what we have in place.
Yeah.
And so I think, if you understand, the handful of rules that are in the rules of council, I think you're pretty well armed to deal with anything that comes before you. And of course, we use several of the rules, such as the motion to refer, quite often to address things that need to be researched more and then brought back to council. So I did want to just take a minute kind of on that. I know it's 2:30-ish and we need to wrap up here soon, but I just wanted to take a minute to talk a little bit about our legislation. So you probably noticed that most of the legislation that comes before council is styled as a resolution. And it's only occasionally that we get something that's styled as a ordinance. This is something that we put in place probably 10 years ago to make it easier to determine what gets sent down to American Legal Publishing for codification and what stays in-house. So resolutions are going to be things like a resolution to authorize the village manager to apply for a grant, resolution adopting the village manager's strategic plan. These are not laws. These are legislative actions, and they are legal in nature because, there has to be authorization for certain things, but they're not a law. It's not like a speed limit. It's not like a business license requirement. It's a resolution to allow the administrative branch and other departments, for example, to take action in accordance with council's policy. An ordinance would be more of an item where we are establishing something or we are amending something. So for example, if we were going to amend the rules of council, we would do that by ordinance. So we would pass an ordinance amending Council Rule 1 to say such and such. And the reason is we want that to be codified. We want that to be part of the Code of Ordinances, part of Chapter 38. And so what we're going to do is we're going to style that as an ordinance. And at the end of the year, we interact with American Legal Publishing, and we will say, well, here are the ordinances that we have passed the prior year. Would you please update our code? And it makes for a very, very efficient process because you're not going through dozens and dozens of resolutions trying to figure out, well, is this one going to be codified or is this one not going to be codified? Because we've done that on the front end. If we don't call it an ordinance on the front end, that means it's not something that gets codified. So in case you've ever wondered why we have the two styles and why you don't see ordinances very much, it's because the ordinances are the ones that are going to actually get codified.
So Deepak, would you say that ordinances are more of a permanent nature and the resolutions are temporary in some sort of fashion?
You could view it that way, sure. And this is something that we just came up with. This is not something you're going to find in Robert's Rules of Order. In many jurisdictions, especially like townships, they'll just call everything a resolution. But I can tell you, because I work for a township, when somebody asks me about a law that was passed and it wasn't something recent, it is a nightmare to go and find it. Right, Emily? Is Emily still there?
Yeah, that is true. There's a lot to look through, that's for sure.
And I say that because I often task Emily with going back and trying to find it. And to make things worse for townships, they don't codify anything. So you're literally at the mercy of whatever document system they're using. Most of them are using PDFs that are posted on their websites. And then if it's not, I forget what that fancy term is, but if it's not something that you can text search, I mean, you're literally just reading and hoping you come across it. So I think the process we have is efficient. It saves the village money because we don't spend a bunch of time trying to figure out what should and should not be codified. And the fact that we have an online portfolio, again, which is something that you don't see with townships, it's excellent because anywhere you are, if you have access to the internet, you can get onto American Legal Publishing. And not just if you're a law director, a manager, or a council member, but if you're a business person and you're trying to figure out, whether or not there's a regulation on your type of business, you can go to this, or your attorney can go to it, and you can research it. It's got what they call the Boolean search capability. So you can type in keywords and you can actually go and search it. I think it's an excellent system, and I've been very happy with it. Any questions about that on resolutions or ordinances? So the final thing I wanted to wrap up with here is I wanted to talk about the process for getting our agenda together. And I'm going to just kind of do an overview, and I'm hoping to just plant a seed. But this is also on page 3 of my outline, and it's under item I as in Idaho, called conduct of business. And what you'll see in there is that in numbers 5 and number 6, the charter calls it the calendar. And so what I've done is I've said agenda/calendar, or printed calendar. And the charter then calls it supplemental calendar, or as I've called it, supplemental agenda. But the basic idea that what the charter tried to do was it tried to create a system where there was a timeline for an agenda to be put together. And we don't typically follow this timeline, and it would be a good idea to begin to work back towards doing that. The idea is that by a certain day of the week, Wednesday, prior to the Monday meeting, council has its packet. Okay, and the idea behind that is that there's time then to read through everything and to digest it. Now that requires all of us to be on the ball, right? So that means you can't give the clerk something, you know, at 4 o'clock on a Wednesday and then expect her to magically produce everything by 5 o'clock, right? So we tried to establish a calendar to complement this, which basically said, if you wanted a piece of legislation by the next council meeting, 2 Fridays before, you had to have it to me in terms of what you wanted. Then I had to have it to the clerk by 8 a.m. Wednesday morning so that she could get the packet together by 5 p.m. Wednesday evening and get it to council so that they had it for 2 or 3 business days prior to the council meeting. Now, that is a very lofty goal. And I'm not saying that we should go back to that, but what I am saying is there is a provision in the charter that does say the Wednesday before council meeting, there should be a packet that goes to council. And then on Friday, I think it's by noon, there can be a supplemental agenda if there's been some emergency items that have come up in the day or two in between. And the only thing I'm kind of counseling there is it would be if we can all start to move towards doing that, where, you know, we're getting our stuff to each other a little bit ahead of time. I think it would allow for council to have more time to review things and digest things, and maybe even call me and ask me questions about things so that, you know, we can begin those dialogues in advance of the meeting. The other thing it does, and this is provided for in the charter as well. If you notice, the first thing the mayor asks when we come to legislation is, she'll say, we have 2021-R-blank. What's your pleasure, council? And what she's asking for is a motion by title only, right? Our rules say that if you get that legislation on Friday or anytime before then, but by Friday, you don't even need to make that motion because you can automatically just read it by title. So it eliminates a procedural motion. It eliminates a motion that needs to be voted on, right? Because we usually do a roll call vote on the motion for title. It just kind of moves that meeting along a little quicker. So I usually don't ever bring that up, even when we do have legislation received ahead of time, because I know it's just kind of become practice, you know, for everybody, and it's not that big a time issue to go ahead and vote on the motion for title. But I just want to plant some ideas out there. we're in training today, and the idea is how can we do things even better? And so I think we do things pretty good, but I think we can do things even better if we could maybe begin thinking about trying to move towards getting information to each other earlier so that the clerk then has the time to prepare a packet earlier that will then allow discussion earlier, and then will allow us to eliminate one of our motions at the beginning, which is the motion to read by title only. So any questions about that?
Yeah, I have something to say. So,
Yes, ma'am.
also when it comes to standing committees, that will help Ms. Randolph just as well to get those agendas, because sometimes she doesn't get anything and she has to basically start it up as a draft agenda, a blank agenda, basically, when she doesn't hear from committee chairs. So it's very important that we do, not just me, the mayor doing what I need to do, but the standing committees as well. It really helps Ms. Randolph to get the information she needs and not to wait till like a day, the day of her preparing for a meeting to ask her for information, which we're going to be talking about Monday at the council meeting, coming up with a better time frame of getting whatever you need from her. Want to request for something, get it to her we're going to come up with a certain time of day, not waiting for the day of a meeting requesting her to turn something around. It's a lot of work. It may not seem that way, but it is.
Yeah, and I think, we do things well, and, the mayor's point, I think, is well taken. If we could just move things up a couple of days, I think it would make everybody's life a little bit easier, and I think it would make for even better meetings.
Yes, I'm sorry, Vice Mayor. Yes, ma'am.
I don't know if Ms. Kiva's hand was up before me or not. Two things. I know that since I've been on council, you've always said that we don't have to make a motion to read by title only. I remember you saying that lots of times. And the other thing would be, I forgot.
That's okay. We coming right back to you. Ms. Key, go ahead. Yes, we are. Go ahead, Ms. Key.
Thank you. I apologize ahead of time. We have my nephew's playing a football game in the other room, and my husband's redoing a closet in the basement. So it's a little loud in my office today, but more procedural questions. So one, I do like, although I know you said it's a lofty goal to kind of go back to getting the legislation ahead of time. I do like that option of getting it ahead of time so that we can read it, because I do not like getting it on Monday afternoon and then being prepared to vote on it. It is like a pet peeve of mine, and that's because I want to read it and digest it. So that was one point. The other one is whenever there's an attachment or whenever there's anything that says as seen, anything that's supposed to be with can we have that full legislation, before we even get to council? That would be helpful for me, because as you know, I'm very consistent with that. I'm always looking for where's the details. And then the third one is we talked about kind of speeding up for Ms. Randolph. Sometimes when there's a council member who is not present, but she says their name anyway, even when we're voting. Is that a rule that she has to say their name? Like if they've already been identified as not being in the meeting, does she have to say their name whenever we're doing a vote?
No, she doesn't, and that's a very good point. Miss Randolph, I like the thoroughness that Miss Randolph is trying to emulate by doing that. But yeah, once the record reflects that council member John or council member Jane is absent, you don't need to call their name in the roll call. And sometimes we have the situation where somebody is delayed due to circumstances beyond their control. And so typically what the mayor does is when they make their entrance, the mayor will say, let the record reflect that council member John has entered the meeting at 8:15. And then that's the cue to Ms. Randolph to then include them in the vote, and the record reflects that. But that's a very good point. Ms. Randolph, if you want to eliminate having to keep going through that absent person every roll call vote, you can certainly do that.
Yes, Vice Mayor.
I think that sometimes we ask our clerk of council for things that we can get on our own. And then we wonder why she don't have the minutes ready for it. Some things that we could do on our own. You can't ask her to research something that you're working on. You can Google it, and that's me included. I think that we should be able to, if we're taxed with doing a project, I haven't called her and asked her to call ANS Party Rentals, Academy Rentals, or anything to do my Lincoln Heights Day stuff. That's stuff that I'm tasked to do. So things that we can do on our own, I think it's fair that we do it on our own. Now, certain things we have to, can you go and look this up for me? Because I need a copy of it. I don't have access to that. Something we don't have access to, yes. But if we can do it on our own, I don't think that we should have her do that. That's just my opinion.
Good insight, Vice Mayor. Mr. Desai, before you go further, since we're talking about clerk of council, I would like to ask Ms. Randolph if there's something that she would like to add or suggest, since we are in training.
I just agree with everything that's been said. Sometimes it can be a little disheartening to find that I have to constantly, not constantly, but I have to try to see if I can get a council person to send me their agenda or whatever information they want for their meetings, because that time could be used to get it together as opposed to emailing and calling. Because my opinion is that they've been this chair of this committee for I don't know how many months or years, and it's something that comes every month, the meeting. So I'm thinking maybe they should say, okay, I know I have to get this to her. I may be late, but I know I have to get it to her, so she would not have to call me or email me or see if somebody else on council, because I've done all three, somebody else on council can help me contact this person. It's just about just trying to be time effective. And I'm not saying I got everything perfect, but I just try to dot my I's and cross my T's as much as possible and get things done in a timely fashion. Because sometimes we're not aware that it takes time. Sometimes you'll say, okay, clerk of council, I need you to do 1, 2, and 3, and I need this by the next meeting. And after doing research on one particular project recently, I've incorporated the help of other people in the administration to help me find it, because I have not been able to. I've contacted Mr. Mercer in this particular instance, and also Attorney Desai. So that's time that I could be doing transcriptions and other things, but it was over a period of days. So I just want to say thank you to all of those who said what they said, Vice Mayor and Councilwoman Key and Mayor. Thank you.
You're welcome. Yes, Vice Mayor.
However, now if it's a task and it takes you a couple of days or something like that, or if not you, I'm not saying you, the person in the position, a couple of days, I would think that whoever asked that information would assist in that too. I know sometimes I can be a little harsh, but I really believe in just human kindness. I really, really do think that it's easier to be kind with somebody. You'll probably get the information quicker. And if you assist somebody, 2 are better, it's better than 1. And sometimes I know I've done it. Oh, I don't feel like doing it, so I'm gonna give it to somebody else. I've been in a position where I could do that, and that's not fair. It wasn't fair, and it's not right. So that's all.
All right.
Well, everybody, thank you for your comments. I'm done with my piece of the presentation. I'm sorry, I know we went a little bit longer than 2:45, but I hope you found it valuable, and I hope the day has been great, and you're invigorated and even more excited about leading the Village of Lincoln. So thank you very much.
All right, Ms. Key.
Mayor, I'm not going to belabor our training, but I would like to see if we have an opportunity for Mr. Desai to maybe take small chunks of his training and give us some additional training, whether it be through committee of a whole, and you can take a section, because I do think that it's needed, because there's a lot of areas that we can all tighten up. So I don't know how that might look, but not to have training just once every 2 years or once a year or something like that.
Yeah. I do know last year, before COVID hit, we had started talking about discussing rules of council, a segment of rules of council, you know, and the charter, different parts during committee of the whole. Well, things fell by the wayside with COVID, and it was when we were in person. So that is a good idea, and we can start revisiting that. And even if it's a segment, so Mr. Desai, you know where our strengths is and what we need to grow on. I would like to, you know, yeah, I see a clap. Is that a hand clap? Or I want to speak, Ms. Mitchell.
No, I want to speak, but I'm clapping too, because there's a
Okay.
lot that's been said today, especially about getting that council packet together. I
Mhm.
think you and Lisa know that that's something that I'm a stickler for, getting information ahead of time, as well as my finance report, you know, so that we can be prepared. And I think that's that is so critical. But I think this the training has been really good, and I agree with Ms. Key that, you know, some intermittent training on an issue or something that is in the charter that we might overlook, like some of the parts that's not necessarily in the rules of council, but actually in the charter, so that we make sure that we are as compliant as we can be. I think that is necessary. The other question, Mayor, is what Mike gave us, will that qualify for us having done the public records requirement for the state? Because typically they ask for that at an audit.
I will make sure it's posted, especially since it was recorded and it was public. Yes, I don't see why not, because it's actually what the Ohio and this, well, the Center for Local Government referred us to him, and they actually teach that when we do go to the elected official training.
So will we get a certificate or a letter or something stating that we have taken the training?
I can get that. I can make that happen.
Thank you, ma'am.
You're welcome. I am going to go around. We're going to do it around. So I would like to hear from each council member, because what we say, it makes us grow as a group. So Councilman Daniels, I would like to hear from you on today's training. You have anything? All right, we got to come back. Ms. Baber, anything you wanted to add on today's training, or anything you would like to say?
No, thank you, Mayor. Have a blessing.
You too. All right, Vice Mayor, anything else from you? Ms. Childs Jeter.
No, thank you.
You're welcome.
Today was a good day, but I'd like to see more and learn more from Mr. Desai. I think there's some other areas that we need to cover so that council will be strengthened. So thank you. Good day. Good day, Mayor.
Oh, you're welcome.
And let me also say that for Ms. Randolph, you've been great, absolutely great. And I want to thank you for your service.
Yes. Ms. Powdrill, anything you'd like to say?
No, Mayor. Thank you.
You're welcome. Well, I just want to say, oh, Emily, we want to make sure you're.
Yeah, I mean, I think you guys have, I think there's a lot of good information. I think the whole training session has been good. I mean, I've learned a lot, even from, you know, the first two presenters. And I mean, I can still stand to learn a lot more from Deepak, but it's nice to hear how engaged everyone is and everyone just wanting to learn, and I'm in the same boat. So I think it's been really helpful. Thanks.
All right, well, thank you. Ms. Randolph, you know, I want to say thank you for all that you do and all that you put up with us, because I know that job is not an easy one, but we want to thank you for your service and all that you do in helping with the preparation of today's training. We were boots on the ground for the last 2 weeks, so I want to thank you for incorporating, and it was her idea to come up with the packets and things. And my idea, you know, I like to eat, was for the lunch, along with some ideas from Ms. Powdrill. So thank you both. Yes, Mr. Desai?
Thank you, Mayor. I did just want to say to everyone, and I apologize for not mentioning this earlier, that Emily being here this morning was by no mistake. Emily began working with our firm when she was a second-year law student, and I believe that was 2019. Emily is now graduated. She's taken the bar, and
Congratulations.
Congratulations.
Thank you. Thanks.
And we're integrating Emily into our municipal practice. I think, as everyone knows, you know, we represent Gulf Manor, Montgomery, Sycamore Township, Lincoln Heights. We've done Hamilton Township. I'm doing a matter for Blue Ash right now, and our firm, it views us as a team. While I might be the law director for Lincoln Heights, Terry might be the law director for Montgomery. The people at those municipalities will call upon others in our firm to help, and Emily is going to be a big part of that. So just know moving forward that you're going to be seeing more of Emily. If you can't reach me, you can always reach out to Emily. But, you know, I want to make sure everyone knows that, you know, one of the best things about me moving to Donelon and Miller a few years ago is that rather than it just being DPOC, there's actually a team there to help support Lincoln Heights. So look forward to seeing her more and more, and maybe even covering some meetings in the not too distant future.
Thanks, Deepa.
Where are you going?
I'm going to be here. I'm going to be here. But, you know, the only way you can learn is if you do, right? So,
Hello.
you know, so Emily's ready to take her nose out of the book and put her feet on the ground. You know what I'm saying?
Yeah. Ms. Giles Jeter?
Yes, I also want to thank Gigi because she had to do the ICRC today.
Thank you, Gigi.
Yeah.
Thank you, Miss Gigi.
Yeah.
Thank you.
Yeah.
Madam Mayor,
Yes, ma'am.
I just want to say too that I learned a lot today, and I really have a lot to benefit from because of this day going forward, as far as doing what I do, and learning some more intricacies about council's rules and regulations. So I just want to say thank you for that.
You're welcome. I want to thank ICRC, Ms. Gigi, your whole group organization that has always allowed us, whatever we had planning for the Village of Lincoln Heights, they have always, especially in this era of COVID, have made themselves available for us to get the word out to our residents as we continue to grow the village. To the residents that are watching, we thank you for watching us. So you do know that we do not take it lightly as elected officials and as our administrative staff and body. We're here at the Village of Lincoln Heights to do what's needed to make our village grow. So I want to thank anyone that's watching, and we wanted to make it possible for you guys to be able to see. Normally, if we were in conferences, you would not be able to see this information given to us. So we're doing it because we want to be held accountable. We believe in transparency, and we want to thank the residents for just even electing us to do the business of the village. So without anything else, I have to say thank you, and you all have a great Saturday. And the Vice Mayor has, go ahead, Vice Mayor. You know, I mean, why is she ready to go? She said, Mayor, wrap it up. All right. Have a good afternoon, everybody.
Thank you, everyone. Bye-bye.
Bye-bye.
Thank you.